same time, rather than requiring each person or business to sue separately. Now, not everyone in the class will testify, but you may assume that the evidence admitted during trial applies to all class members unless I tell you otherwise. The fact that this case is proceeding as a class action does not mean any decision has been made about the merits of the case. And you must not infer anything about the merits of this case based on the fact that it is a class action. Now, in this case, the class is called you're going to hear this a lot, so remember this term. In this case, the class is called the Direct Purchaser Plaintiffs, or DPPs, and it consists of the following members. All persons or businesses in the United States who purchased capacitors directly from any of the defendants from January 1, 2002 to December 31, 2013. The direct purchaser plaintiffs representing the class in this trial are a company called Chip Tech Limited and another company called EIQ Energy, Inc. Now, to help you follow the evidence, I will give you a brief summary of the positions of the parties. The plaintiffs are the direct purchaser plaintiffs, who I just told you about, and the defendants are Nippon Chemicon Corporation and United Chemicon, Inc., and they are referred to as NCC and UCC, respectively. AVX Corporation, referred to as AVX, and Matsuo Electric Company Limited, referred to as Matsuo. Now, defendants manufactured and sold one or more types of aluminum, tantalum, and/or film capacitors. Now, the DPPs allege that defendants and others conspired directly and indirectly with each other in an overarching scheme to control and set the prices of their aluminum, tantalum, and film capacitors sold to United States purchasers and purchasers worldwide from January 2002 until December 31, 2013. January 1st, 2002 until December 31, 2013. The DPPs have the burden of proving this alleged conspiracy. The defendants deny the DPP's claims. Now, when a party has the burden of proving any claim or affirmative defense by a preponderance of the evidence, it means you must be persuaded by the evidence that the claim or affirmative defense is more probably true than not true. You should base your decision on all of the evidence, regardless of which party presented it. Now, the parties in this case are corporations. All parties are equal before the law, and a corporation is entitled to the same fair and conscious consideration by you as any party. Under the law, a corporation is considered to be a person. It can only act through its employees, agents, directors, or officers. Therefore, a corporation is responsible for the acts of its employees, agents, directors, and officers performed within the scope of authority. An act is within the scope of a person's authority if it is within the range of reasonable and foreseeable activities that an employee, agent, director, or officer engages in while carrying out that person's business. Now, the evidence you are to consider in deciding what the facts are consists of 1, the sworn testimony of any witness, 2, the exhibits that are admitted into evidence, 3, any facts to which the lawyers have agreed, and 4, any facts that I may instruct you to accept as proved. Now, in reaching your verdict, you may consider only the testimony and exhibits received into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. I will list those for you. 1, arguments and statements by lawyers are not evidence. The lawyers are not witnesses. What they may say in their opening statements, closing arguments, and at other times is intended to help you interpret the evidence, but it is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. Number two, questions and objections by lawyers are not evidence. Now, attorneys have a duty to their clients to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by my ruling on it. Number three, testimony that is excluded or stricken or that you are instructed to disregard is not evidence and must not be considered. In addition, some evidence may be received only for a limited purpose. When I instruct you to consider certain evidence only for a limited purpose, you must do so. You may not consider that evidence for any other purpose. And number four, anything you see or hear when the court was not in session is not evidence. You are to decide the case solely on the evidence received at the trial. Now, evidence can be direct or circumstantial. Direct evidence is a direct proof of a fact, such as testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is proof of one or more facts from which you can find another fact. You should consider both kinds of evidence. The law makes no distinction between the weights to be given to either direct or circumstantial evidence. It is for you to decide how much weight to give to any evidence. Lisa, would you lock the doors, please? No one coming in and out during jury instruction. Just one moment, ladies and gentlemen. All right, now let's turn to instruction number 9. These are the stipulations of fact that I mentioned a moment ago. Now, the parties have agreed to certain facts that I will now read to you. They have stipulated that certain electrolytic capacitor manufacturers, but not others, were convicted of violating the United States antitrust laws. So you must treat these facts as having been proved. Number 1, for the Matsuo Electric Company Limited. Defendant Matsuo Electric Company Limited pled guilty to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of Matsuo's guilty plea, the relevant period is the period beginning at least as early as November 2001 until in or about January 2014. During the relevant time period, Matsuo was a corporation organized and existing under the laws of Japan. Matsuo had its principal place of business in Osaka, Japan. During the relevant period, Matsuo manufactured tantalum electrolytic capacitors and was engaged in the sale of such electrolytic capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. Tantalum capacitors are a type of electrolytic capacitor. During the relevant period, Matsuo, through its officers and employees, including high-level personnel of Matsuo, participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, Matsuo, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the conspirators agreed to fix the price and/or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, Matsuo and its co-conspirators manufactured certain electrolytic capacitors outside the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California. Certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. Matsuo employee Satoshi Okubo also pled guilty. All right, now for Nippon Chemicon Corporation. Defendant Nippon Chemicon Corporation pled guilty to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of electrolytic capacitors sold in the United States and elsewhere in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of NCC's guilty plea, the relevant period is that period beginning at least as early as November 2001 until in or about January 2014. During the relevant period, NCC was a corporation organized and existing under the laws of Japan. NCC had its principal place of business in Tokyo, Japan. During the relevant period, NCC manufactured electrolytic capacitors and was engaged in the sale of such capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. During the relevant period, NCC, through its officers and employees, including high-level personnel of NCC, participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors manufactured outside of the United States and sold in the United States and elsewhere. In furtherance of the conspiracy, NCC, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During these discussions and meetings, the conspirators agreed to fix the price and/or rig bids of certain electrolytic capacitors manufactured outside of the United States to be sold in the United States and elsewhere. During the relevant period, NCC and its co-conspirators manufactured electrolytic capacitors outside the United States and sold them in the United States for delivery to the United States. During the relevant period, electrolytic capacitors sold by one or more of the conspirator firms traveled in and substantially affected interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California, and electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. Now that's for the NCC. UCC, United Chemicon, did not plead guilty. 6 other manufacturers of electrolytic capacitors who are not parties to this lawsuit also pled guilty. So the next batch that I'm reading are not parties in the case, but they are guilty pleas that the parties have stipulated to in the following fashion. For their Elna Company Limited, Elna Company Limited, which is not a defendant, pled guilty to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere, in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of ELNA's guilty plea, the relevant period is the period beginning at least as early as August 2002 until in or about January 2014. During the relevant period, ELNA was a corporation organized and existing under the laws of Japan. ELNA had its principal place of business in Yokohama, Japan. During the relevant period, ELNA manufactured electrolytic capacitors and was engaged in the sale of such electrolytic capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. During the relevant time period, ELNA, through its officers and employees, including high-level personnel of ELNA, participated in a conspiracy among manufacturers of electrolytic capacitors, primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, ELNA, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the conspirators agreed to fix the price and/or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, ELNA and its co-conspirators manufactured certain electrolytic capacitors outside of the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California, and certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more conspirators to customers in this district. Now, ELNA America, Inc. Did not plead guilty. ELNA employee Tokuo Tatai and former employee Satoshi Okubo also pled guilty. Those are individuals. All right, for Hitachi Chemical Company Limited. Hitachi Chemical Company Limited, which is not a defendant, pled guilty to participating in a conspiracy to suppress and eliminate competition, fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of Hitachi's guilty plea, the relevant period is the period beginning at least as early as August 2002 until at least as late as March 2010. During the relevant period, Hitachi was a corporation organized and existing under the laws of Japan, and Hitachi had its principal place of business in Tokyo, Japan. During the relevant period, Hitachi manufactured aluminum and tantalum electrolytic capacitors and was engaged in the sale of aluminum and tantalum electrolytic capacitors in the United States and elsewhere through certain current and former subsidiaries, including entities known during the relevant time period as Hitachi AIC, corporation organized and existing under the laws of Japan with its principal place of business in Tochigi Prefecture, Japan, and Hitachi Chemical Electronics Company Limited, a corporation organized and existing under the laws of Japan with its principal place of business in Ibaraki Prefecture, Japan. At a certain point after the relevant period, Hitachi assumed responsibility for the sale of electrolytic capacitors from subsidiary Hitachi AIC Inc. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. Aluminum and tantalum capacitors are types of electrolytic capacitors. During the relevant period, Hitachi, through its officers and employees, including high-level personnel of Hitachi, participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, Hitachi, through its officers and employees of certain current and former subsidiaries, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the conspirators agreed to fix the price. Let me take that from the beginning. During certain of these discussions and meetings, the conspirators agreed to fix the price and/or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, Hitachi and its co-conspirators manufactured certain electrolytic capacitors outside the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California, and certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. Now I'm returning to Holy Stone Holdings Company Limited. Holy Stone Holdings Company Limited is not a defendant and pled guilty on behalf of its former subsidiary, Holy Stone Polytech Company Limited, which will be referred to as HPC, to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere, in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of Holy Stone Holdings' guilty plea, the relevant period is the period from in or about April 2010 until in or about January 2014. During the relevant period, Holy Stone Holdings was a corporation organized and existing under the laws of Samoa, with its principal place of business in Apia, Samoa. During the relevant period, Holy Stone Holdings' wholly owned subsidiary, Holy Stone Polytech Company, HPC, was a manufacturer of tantalum electrolytic capacitors headquartered in Miharu, Fukushima, Japan, and was engaged in the sale of such capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. Tantalum capacitors are a type of electrolytic capacitor. During the relevant period, HPC, through its officers and employees, including high-level personnel of HPC, participated in a conspiracy among manufacturers of electrolytic capacitors, primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, HPC, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the capacitors agreed to fix the price and/or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, HPC and its co-conspirators manufactured certain electrolytic capacitors outside the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California, and certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. Holy Stone Enterprise Company Limited, Milestone Global Technology, Inc., doing business as Holy Stone International, and Vishay Polytech Company did not plead guilty. I think we're just got a couple left. All right, for NEC Token Corporation. NEC Token Corporation, which is not a defendant, pled guilty to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere, in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of NEC Token's guilty plea, the relevant period is the period beginning at least as early as April 2002 until in or about December 2013. During the relevant period, NEC Token was a corporation organized and existing under the laws of Japan. NEC Token had its principal place of business in Tokyo, Japan. During the relevant period, NEC Token was a manufacturer of tantalum electrolytic capacitors and was engaged in the sale of tantalum electrolytic capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. Tantalum capacitors are a type of electrolytic capacitor. During the relevant period, NEC Token, through its officers and employees, including high-level personnel of NEC Token, participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, NEC Token, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the conspirators agreed to fix the price and or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, NEC Token and its co-conspirators manufactured certain electrolytic capacitors outside of the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California. Certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. Now we're moving to the Nichicon Corporation. Nichicon Corporation, which is not a defendant, pled guilty to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere, in violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of Nichicon's guilty plea, the relevant period is the period beginning at least as early as November 2001 until in or about December 2011. During the relevant period, Nichicon was a corporation organized and existing under the laws of Japan. Nichicon had its principal place of business in Kyoto, Japan. During the relevant period, Nichicon manufactured aluminum and tantalum electrolytic capacitors and was engaged in the sale of such capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current, Aluminum and tantalum capacitors are both types of electrolytic capacitors. During the relevant period, Nichicon, through its officers and employees, including high-level personnel of Nichicon, participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, Nichicon, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the conspirators agreed to fix the price and or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, Nichicon and its co-conspirators manufactured certain electrolytic capacitors outside the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California, and certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. Okay, I think we've got two left. Now, for Rubicon Corporation. Rubicon Corporation, which is not a defendant, pled guilty to participating in a conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere, violation of the Sherman Antitrust Act, 15 United States Code, Section 1. For purposes of Rubicon's guilty plea, the relevant period is the period beginning at least as early as August 2002 until in or about January 2014. During the relevant period, Rubicon was a corporation organized and existing under the laws of Japan. Rubicon had its principal place of business in Ina, Japan. During the relevant period, Rubicon manufactured aluminum electrolytic capacitors and was engaged in the sale of such electrolytic capacitors in the United States and elsewhere. Electrolytic capacitors are a major subcategory of capacitors, fundamental components of electrical circuits used primarily to store and regulate electrical current. Aluminum capacitors are a type of electrolytic capacitor. During the relevant period, Rubicon, through its officers and employees, including high-level personnel of Rubicon, participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. In furtherance of the conspiracy, Rubicon, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. During certain of these discussions and meetings, the conspirators agreed to fix the price and or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. During the relevant period, Rubicon and its co-conspirators manufactured certain electrolytic capacitors outside the United States and sold them in the United States or for delivery to the United States. During the relevant period, certain electrolytic capacitors sold by one or more of the conspirator firms traveled in interstate commerce. Acts in furtherance of this conspiracy were carried out within the Northern District of California. Certain electrolytic capacitors that were the subject of this conspiracy were sold by one or more of the conspirators to customers in this district. And the last portion of the stipulation is for Panasonic and Sanyo. Neither Panasonic, Sanyo, nor any of its employees was indicted or convicted of violating the United States antitrust laws. In 2015, Panasonic applied for and was granted amnesty for itself and its employees under the DOJ, that's the United States Department of Justice, the DOJ's corporate leniency program. In doing so, Panasonic admitted to violating the United States antitrust laws and agreed to cooperation obligation with the DOJ, Department of Justice's investigation of the capacitors industry, similar to those agreed to by the entities and persons who pled guilty. All right, those are the stipulations of fact that you can count on as being proven. Let's just take a little stretch break here for a moment and give you a little rest from my voice for a moment. So just get up, just move around, take a little break, make sure everybody's awake. Okay. Let's move on to instruction number 10. These are the rules that control what can be there are rules that control what can be received in evidence. When a lawyer asks a question or offers an exhibit in evidence, and a lawyer on the other side thinks that it is not permitted by the rules of evidence, that lawyer may object. If I overrule the objection, the question may be answered or the exhibit received. If I sustain the objection, the question cannot be answered or the exhibit cannot be received. Whenever I sustain an objection to a question, you must ignore the question and must not guess what that answer would have been. Sometimes I may order that evidence be stricken from the record, or that you disregard or ignore the evidence. That means, when you are deciding the case, you must not consider the evidence that I told you to disregard. Now, deciding the facts in this case, you may have to decide which testimony to believe and which testimony not to believe. You may believe everything a witness says, or part of it, or none of it. In considering the testimony of any witness, you may take into account the opportunity and ability of the witness to see or hear or know the things testified to, the witness's memory, the witness's manner while testifying, the witness's interest in the outcome of the case, if any, the witness's bias or prejudice, if any, whether other evidence contradicted the witness's testimony, the reasonableness of the witness's testimony in light of all the evidence, and any other factors that bear on believability. Now, sometimes a witness may say something that is not consistent with something else he or she said. Sometimes different witnesses will give different versions of what happened. People often forget things or make mistakes in what they remember. Also, two people may see the same event but remember it differently. You may consider these differences, but do not decide that testimony is untrue just because it differs from other testimony. However, if you decide that a witness has deliberately testified untruthfully about something important, you may choose not to believe anything that witness said. On the other hand, if you think the witness testified untruthfully about some things, but told the truth about others, you may accept the part you think is true and ignore the rest. The weight of the evidence as to a fact does not necessarily depend on the number of witnesses who testify about it. What is important is how believable the witnesses were and how much weight you think their testimony deserves. Now, at times during trial, you may hear testimony by a witness in the form of a previously recorded deposition rather than live here in court. A deposition is the sworn testimony of a witness taken before trial. The witness was placed under oath to tell the truth, and lawyers for each side asked questions. Questions and the answers were recorded. Insofar as possible, you should consider deposition testimony presented to you in court in lieu of live testimony in the same way as if the witness had been present to testify. You will also hear testimony from individuals known as expert witnesses who testify to opinions and the reasons for their opinions. This opinion testimony is allowed because of the education or experience of the witness. Such opinion testimony should be judged like any other testimony. You may accept it, reject it, or give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. The evidence that a witness lied under oath or gave different testimony on a prior occasion may be considered, along with all the other evidence, in deciding whether or not to believe the witness and how much weight to give to the testimony of this witness, and for no other purpose. Now, certain charts and summaries not admitted into evidence may be shown to you in order to help explain the contents of books, records, documents, or other evidence in the case. Charts or summaries are only as good as the underlying evidence that supports them. You should, therefore, give them only such weight as you think the underlying evidence deserves. Certain charts and evidence may be admitted. Certain charts and summaries may be admitted into evidence to illustrate information brought out in the trial. Charts and summaries are only as good as the underlying evidence that supports them. You should, therefore, give them only such weight as you think the underlying evidence deserves. Now, you will hear testimony from witnesses testifying in Japanese or Chinese languages. Witnesses who do not speak English or are more proficient in another language testify through an official court interpreter. Although you might know Japanese or Chinese and be tempted to rely on your own understanding of these languages, you cannot do that because it is important that all jurors consider the same evidence. You must accept the interpreter's translation of the witness's testimony and disregard any different meaning or interpretation from any other source, including your own understanding of the language. You must not make any assumptions about a witness or a party based solely on the use of an interpreter to assist that witness or party. Now, you will see English translations of documents that were written originally in Japanese, Chinese, or other foreign languages. Some documents will be presented with a single translation into English. You must accept the translation of the document and disregard any different meaning or interpretation from any other source, including your own understanding of the foreign language that you might have. The translation is the evidence, not the foreign language in the original document. This is important to ensure that all jurors consider only the same evidence. Now, some documents might be presented with two different translations into English because the parties could not agree on a single translation. In that case, you must decide whether a translation is accurate in whole or in part. In considering whether a translation accurately states the words in a document, you should consider the testimony presented to you about how and by whom the translation was made. You may consider the knowledge, training, and experience of the translator and the reasonableness of the translation in light of all the evidence in the case. You must not rely in any way on any knowledge you may have of the language in the original document. Now, I urge you to pay close attention to the trial testimony as it is given. During deliberations, you will not have a transcript of the trial. Now, if you like, you may take notes during trial to help you remember the evidence. Your binder has no paper in it. If you do take notes, please keep them to yourself until you go to the jury room to decide the case. Do not let note-taking distract you. And when you leave each day, your notes should be left in the jury room. No one will read your notes. Whether or not you take notes, you should rely on your own memory of the evidence. Notes are only to assist your memory. You should also not be overly influenced by your notes or the notes of other jurors. Now, when the attorneys have finished examining a witness, you may propose a question to the witness to help clarify the testimony. Now, a question may not be used to express any opinion about the testimony or argue with the witness. If you propose a question, remember that your role is that of a neutral fact finder and not an advocate. So if you're hearing testimony and maybe you missed something and you want to confirm a date, you can write a question down. I'll tell you what the procedure is. Or that's a basic illustration of, but anything else on a fact nature. But obviously no questions like, well, why does your testimony differ from the other witness? Those are two, that's not a fact issue. That's for you to think about later, but not ask the witness. Okay. Before I excuse each witness, I will offer you the opportunity to write out a question using the form that has been put into your binders. Did we put the form in the binders? The form that will be provided for you to be put in your binders. Do not sign the question. Don't put your name down, okay? If there are some proposed questions, I'll get the questions, I'm going to look at them. There are some proposed questions that I will not permit or will rephrase from the wording you submitted. This might happen either due to the rules of evidence or other legal reasons, or because the question is expected to be answered later in the case. But if I do not ask your question, or if I rephrase it, don't try to figure out why or speculate for the reasons. And do not give undue weight to questions you or other jurors propose. You should evaluate the answer to those questions in the same manner that you evaluate all the other evidence. And just let me add, if I don't ask your question, please don't be offended. There are reasons I didn't. It's not anything about you, it's about the question. By giving you the opportunity to propose questions, I'm not requesting or suggesting that you do so. It will often be the case that a lawyer has not asked a question because it is legally objectionable or because a later witness may be addressing that subject. This is our closing instruction, very important. Let's just talk now about your conduct as jurors. I touched on this yesterday, but this is something that needs to be kept in mind at all times. It is vitally important that you keep an open mind throughout the trial. The testimony and evidence will unfold over several weeks, and you should not reach any conclusions before you have heard everything that will be presented. In addition, do not decide what the verdict should be until you and your fellow jurors have completed your deliberations at the end of the case. When it comes time for you to decide the verdict, your decision must be based on the evidence received in the case and on my instructions on the law that applies. You must not be exposed to any other information about the case or to the issues it involves during the course of your jury duty. For these reasons, do not communicate with anyone in any way, and do not let anyone else communicate with you in any way about the merits of the case or anything to do with it. This covers every possible form of communication, in person, in writing, by phone, email, text messaging, any social media like Facebook, Twitter, Instagram, or any other form of communication. The prohibition of communication applies to everyone, including your family members, your employer, the media or the press, and the people involved in this trial. It also applies to communicating with your fellow jurors until I give you the case for deliberation. Now, you are free to tell your family and employer that you have been seated as a juror in the case and how long you expect the trial to last, but you cannot share with them or anyone else any other information about your jury service or about the case. If anyone asks you about your jury service or the case, you must say that you have been ordered not to discuss the matter, and you must also promptly report the contact to me through Ms. Clark. In addition, you must not for any reason do any research or investigation on your own. You will get all the evidence and legal instruction you may properly consider for the verdict right here in the courtroom. Do not look up anything on the internet or in a book or do any sleuthing or investigating of any sort. Do not visit or view any place or location that might be described during the case. Do not do any research about the law or the people involved in this case, including the parties, the witnesses, the lawyers, or me. Also, while I have no information that there will be any media coverage of this case, please make sure that you do not read, watch, or listen to any news or media accounts or commentary about the case or anything to do with it. If you happen to read or hear anything touching on this case in the media, turn away and let me know what happened by telling Ms. Clark. I know this is a long list of don'ts, but it is vitally important for you to follow these rules. They protect each party's right to have this case decided only on the evidence that has been presented here in court. Witnesses in court take an oath to tell the truth, and the accuracy of their testimony is tested through the trial process. If you do any research or investigation outside of the courtroom or gain any information through improper communications, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process. Each of these parties here is entitled to a fair trial by an impartial jury. And if you decide the case based on information not presented in court, you will have denied the parties a fair trial. And remember, you have taken an oath to follow the rules, and it is crucial that you do follow these rules. A juror who violates these restrictions jeopardizes the fairness of these proceedings. And if any juror is exposed to outside information and you hear about that, you must notify me immediately. Now we're just about to start the trial. We're going to take a little break first. We'll take our morning break. Each side may make an opening statement. I want to emphasize, as I said earlier, opening statement is not evidence. It's not evidence. It is simply an outline from the party to help you understand what the party expects the evidence might show. Now, a party is not required to give an opening statement, and if a party chooses not to do one, you should not hold it against the party for any reasons. After the opening statements, the DPPs will present evidence, and counsel for the defendants may cross-examine, and then the defendants will present evidence, and the counsel for the DPPs may cross-examine. After the evidence has been presented, I will instruct you on the law that applies to the case, and the attorneys will then make their closing arguments. And after that, you go to the jury room to deliberate on your verdict. Okay, we'll take our 15-minute morning break, and while you're in there, I'll see if I'll get the written question forms passed out as well. Can you do that?
All right. Okay. We're back on the record in civil 14-3264 and multi-district litigation 17-2801 and rate capacitors antitrust litigation.
All right, ladies and gentlemen, we're going to start the trial now in earnest with opening statements. Because the plaintiff has the burden of proof, they get to go first, and they'll be followed by the defendants who may have a couple of people because there are multiple defendants. And remember, as you just were instructed, this is not evidence. Nothing that the lawyers say for either side is evidence. It's just they're giving you their understanding of the case and what they hope to prove, or they may show along the way some charts and other things. These are called demonstratives. They are not coming into evidence. You will not see them in the jury room. They're not being admitted into the record. They're just visual aids to help you understand the presentations during the statements. So with that, Mr. Severi for the plaintiffs will kick us off.
For over 12 years, the defendants illegally conspired to reduce and eliminate and prevent competition. They agreed with each other that they would raise prices when they could. They agreed with each other to keep prices as high as possible when they could. And when prices were going down, they worked together to prevent that. In doing so, the defendants broke the law and caused the plaintiffs to pay higher prices than they otherwise would have. Good morning, members of the jury. My name is Joseph Severi, and I have the honor of representing the plaintiffs in this case. The plaintiffs in the case are EIQ and Chiptech. They represent a class of large and small purchasers of capacitors in the United States. You will learn during this trial that the defendants agreed with one another to elevate prices of capacitors in the United States. And let me use the easel for a second. The defendants conspired to charge more for their products than they would have been able to charge if there were not the conspiracy, if there had not been honest competition. The conspiracy lasted for 12 years. The conspiracy lasted from 2002 through 2013. We will prove that the defendants knew what they were doing was wrong and tried to conceal and hide it. These companies cheated, not competed. The plaintiffs in this case are the purchasers of three different types of capacitors you heard about in the instructions. The three different types of capacitors that are issue in this case and the subject of the conspiracy are aluminum, film, and tantalum capacitors. Now, the plaintiffs in this case are the purchasers of capacitors. Distributors and manufacturers who paid more for the capacitors than they should have if there had not been a conspiracy and the defendants had acted legally. The defendants are the companies that manufactured and sold the capacitors to purchasers in the United States. The defendants are the United States and Japanese businesses doing business in the United States and breaking the United States antitrust laws. Some of the defendants are based in the United States. Some of the defendants are based in the United States and owned by Japanese companies. Some of the defendants are Japanese companies that operate in the United States through companies they own. Some of the defendants operate facilities in Asia, in China, in Singapore, in Hong Kong. Some of the defendants operate factories in Europe, in Germany, and some in Mexico. But all of them did business in the United States and sold capacitors in the United States and are governed by United States antitrust laws. How did the defendants, the conspirators, violate the law? By communicating with each other over the phone, via email, by telephone, and in in-person meetings. First, they agreed generally to limit competition on prices, ensuring that their profits would be higher and making sure that their customers paid too much. Then they regularly met together and spoke on the phone and communicated by email. The other key ingredient or part of the conspiracy was the exchange of information. They did this to maintain their general agreement on prices and to agree on prices for particular customers, for particular types of customers, and for particular parts of the world. I almost ran out of room. Sometimes it was the presidents of these companies that met together. Sometimes it was their lower level staff or their assistants who met together carrying out the agreements that their presidents made. There were many meetings and communications where, as agreed, the conspirators agreed to provide each other with confidential information regarding their businesses, their plans, and the prices that they expected to charge. So we will prove in this case, one, that there was a conspiracy. We will show you the key purposes and goals of the conspiracy. We will prove to you the scope of the conspiracy. And we will prove to you the effects of the conspiracy. That is, the amount of money that my clients paid that they shouldn't have had to pay. Now, some of the communications in this case happened regularly every month. These occurred at monthly meetings where the conspirators tried to reach general understandings about raising prices when they could, maintaining them as much as possible when they were staying the same, and doing what they could to prevent prices from decreasing when the market was going down. Now, these monthly meetings were regular and well organized. Before the meetings, the companies would all fill out forms in a pre-agreed form. And these forms would contain highly confidential and sensitive information. It would include information about recent sales figures, but also their future plans for selling capacitors. Sometimes the meetings would address strategies for pricing on particular products, for particular types of customers, and for particular customers also. And as our experts will explain in this case, this is the kind of information that companies that were competing with one another would not exchange, because they wouldn't want to give their rival, the companies that they were competing against, an unfair advantage. Wouldn't want to give their competitors an advantage. But this is also the type of information that companies that were working together, that were colluding, that they would share that kind of information because it would allow them to monitor each other and to make sure that the agreements that they reached were being followed. And this was a way of avoiding future competition with respect to prices. So let me introduce to you some of the plaintiffs here today. They are the class representatives, as the judge talked about a few minutes ago. The first is Gene Kraswinski. Mr. Kraswinski, please stand up. Thank you. Now, Mr. Kraswinski is the founder and CEO of a company called EIQ. EIQ is a startup technology company based in San Jose, California. Currently, it has 7 employees. Now, Mr. Kraswinski founded EIQ in 2002, and the primary product of EIQ is something called a V-boost, which is used to convert power generated by solar panels. This is a V-boost, which Mr. Kraswinski is very proud of, you will hear. As you will hear, as with most electrical products, capacitors are crucial to their operation. Without capacitors, a V-boost would not work. Now, EIQ bought capacitors from NCC through its US sales subsidiary, UCC, for use in the V-boost. Mr. Kraswinski will testify that the capacitor purchased from NCC was one of the single most expensive components used to manufacture the V-boost. You will also hear from Barry Lubman, the Vice President and COO of Pride Electronics, whose sister company, Chiptech, filed the first lawsuit in this case. Now, Mr. Lubman's company bought all sorts of capacitors. They bought them directly from the defendants during the 2002 to 2013 period. Pride was originally founded in 1965, and for decades, it and its sister company has sold capacitors and other electric components to various types of industry, like the military, for automobiles, for medical devices. They bought millions of dollars of capacitors from the defendants in this case. Here, altogether, my clients purchased $5 billion worth of capacitors during the 2002 to 2013 period, directly from the defendants or their co-conspirators. And when they did that, they paid too much. And they are seeking here to get the money back that they were forced to pay. Now, as you will learn, a conspiracy existed. 10 of the companies have admitted to participating in a price-fixing conspiracy. You will learn that the defendants agreed and coordinated and communicated with each other so that they would not have to compete with one another. And they did that because competition would have meant lower profits for them and lower prices to their customers. Now, 8 of the companies were prosecuted for violating the criminal laws against price fixing in the United States and pled guilty. 1 company turned the others in. So this slide shows the corporations, the corporate families that have admitted to price fixing. Each company admitted that they committed acts in furtherance of the conspiracy here in the Northern District of California. And what the Northern District of California means is it's this area where this courthouse is located in the state. Each of the companies admitted to participating in the conspiracy. That is Nippon Chemicon, Panasonic, Nishikon, Rubicon, Sanyo, Elna, Hitachi, NEC Token, Matsuo, and Holy Stone. These guilty pleas mean that these companies were charged with a crime, they admitted their wrongdoing, and negotiated a plea bargain. In addition, there were two individuals who also admitted participating in a price-fixing conspiracy. One was Mr. Satoshi Okubo, who worked for two companies that pled guilty. One was Elna, and one was Matsuo. Another was named Tokuo Tatai, who worked for the Elna company. And again, both of these individuals were charged with a crime, admitted to wrongdoing, and these individuals were incarcerated at the prison at Lompoc. Would you show the next slide, please? So in this slide, I've listed the 22 companies that engaged in the conspiracy. In the right column, you'll see the 4 companies that are defendants in this case. Now, if you count the rows here, you will see that it totals 23. And that's because Nippon Chemicon and United Chemicon are both defendants in the case and are listed separately. UCC, as you heard in the instructions, is a wholly owned subsidiary of NCC. So I've just showed you which companies admitted to price fixing and which individuals admitted to price fixing. And these companies, the 22 companies, 23 if you separate Nippon Chemicon and United Chemicon, are the co-conspirators. Now, each of these companies are large organizations with bosses, executives, and managers. They also have low-level staff and other personnel. Many of them are located in the United States, but also in Japan, Taiwan, Hong Kong, Singapore, England, Germany, and many other countries throughout the world. This lower-level staff acted like lieutenants, carrying out the instructions and orders of their bosses that made these agreements. Now, companies act through people. And like many of us, people work for the companies that pay their salaries. And that is what happened here. And because this conspiracy lasted 12 years, and it involved this many companies, there were literally hundreds of people involved in the conspiracy. And we will show you that. But we start from the basic fact from the criminal case that there was a price-fixing conspiracy, and 10 of the companies we sued have admitted they were involved in a price-fixing conspiracy. Now, because of the conspiracy, my clients, the class members, paid $427 million more for capacitors than they would have paid without the price fixing, without the companies breaking the law. That was the effect of the 12-year conspiracy on $5 billion in commerce. We are here asking you to require the defendants in this case to give the class members the money back that they paid that they shouldn't have. But before we go further, let me explain what a capacitor is. Capacitors are components that are incorporated in virtually every electronic product. Virtually every electronic product that has an electrical circuit. Capacitors have been an essential part of electrical circuits for hundreds of years, virtually since the beginning of the modern use of electricity. Now, one aspect of electrical circuits is that the electricity that runs through them needs to be consistent. If the electricity is not consistent, the product won't operate as it should. It may malfunction, stop working, or damage other parts of the product that it is included in. Capacitors are used to control that flow of electricity. There are capacitors in virtually every electronic product. For example, they're contained in computers, or mobile phones, or automobiles, which can contain hundreds of capacitors. They're also in televisions and video game controllers and medical devices like pacemakers. Now, the conspiracy in this case involved aluminum, film, and tantalum capacitors. Aluminum and tantalum capacitors are referred to as electrolytic capacitors. Some of the companies make one type of capacitor, but not the others. Some companies make two, but not the other. Some companies make all three. But every single defendant made at least one type of capacitor and participated in the conspiracy. There is another type of capacitor called a ceramic capacitor. In certain limited ways, ceramic capacitors can be a suitable substitute for aluminum, film, and tantalum capacitors. Ceramic capacitors were first introduced in the 1990s. And during that time, the companies that made the other types of capacitors, including the defendants in this case, discussed how that was going to affect the prices for the aluminum, film, and tantalum capacitors. That gave them a reason to get together and conspire and take the risks associated with that. And they did that to shore up their profits for the products they made. Now, let me turn back to the story. Conspiracy is another word for agreement or scheme or understanding to achieve an illegal purpose. It's a kind of partnership between corporations or persons to do something against the law. I will use the word conspiracy generally to refer to that. And we will prove to you in this case that the companies that I identified formed and joined a conspiracy to control the prices of aluminum, film, and tantalum capacitors. And as I mentioned a few minutes ago, the first proof of that conspiracy that we will show you are the guilty pleas that the defendants entered into. So let me show you one. And these are, this is the same language that the judge read to you in the preliminary instructions. And I wanted to just take a moment to focus on some important aspects. So this is the guilty plea of Matsuo, one of the defendants in the case. And the first thing that Matsuo admits to is engaging in the conspiracy. A conspiracy to suppress and eliminate competition by fixing prices and rigging bids of certain electrolytic capacitors in the United States and elsewhere in violation of the Sherman Act. The next part is the time. For purposes of Matsuo's plea agreement, the relevant period is the period beginning at least as early as November 2001 until in or about January 2014. The next paragraph is the what. During the relevant period, the defendant manufactured tantalum electrolytic capacitors and was engaged in the sale of such electrolytic capacitors in the United States and elsewhere. Elsewhere means that the conspiracy not only included the United States, but other parts of the world. The next part is the who. During the relevant period, the defendant, that's Matsuo in this case, through its officers and employees, including high-level personnel of the defendant, participated in a conspiracy among manufacturers of electrolytic capacitors. Next is the why, the purpose. The primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors sold in the United States and elsewhere. The next is how. In furtherance of the conspiracy, the defendant Matsuo, through its officers and employees, at times engaged in discussions and attended meetings with representatives of other manufacturers of electrolytic capacitors. And then there's the what. During certain of these discussions and meetings, the conspirators agreed to fix the price and or rig bids of certain electrolytic capacitors to be sold in the United States and elsewhere. So from these guilty pleas, and I'm only showing you one and you saw the others, you know the when, the what, the who, the why, the how, and the what. And we will show you copious evidence that supports these conclusions. Now, you will hear in this case the defendants say that what we, the plaintiffs, allege isn't what they pled guilty to. Now, as Judge Donato explained to you, he identified the burden of proof in this case. And in this case, we only have to prove that what we say is more probably true than not. In a criminal case, which is what the guilty pleas were entered into, there's a different burden of proof. Now, you may have seen shows like Law and Order where they discuss this. And in a criminal case, the government has to prove the charges beyond a reasonable doubt. And that's one of our constitutional protections. But in civil cases like this one, the standard is lower. Now, you will hear evidence in this case that the defendants met and communicated with each other many times. There are at least 1,000 of these communications and meetings. There are contemporaneous records of these meetings and communications. The materials prepared in advance of the meetings. The notes taken at the meetings. The reports sent back to the companies by the representatives after the meetings. And the documents confirming who did what based on the agreements and information exchanged. And from these records, it is indisputable that the communications took place in person, via email, or telephone. They occurred in the United States. Many of the meetings or communications occurred in Asia, including Japan, Singapore, Hong Kong, and Taiwan. They occurred in Asia because that's where many of the companies involved in the conspiracy were based. And it's also where a number of the factories where capacitors are made are located. Each of the companies that pled guilty have significant operations in Asia. By going to these meetings, as we will prove, the participants actively joined the conspiracy, a conspiracy to violate U.S. antitrust laws, and they worked together to achieve the conspiracy's common purposes. You will learn that these meetings were attended by the CEOs of the companies, but also by the managers and salespeople of the Japanese companies. This was not some group of rogue employees. The people who went to the meetings did so because it was part of their job and their assignment. At the meetings, they represented the companies they worked for. They knew the others did as well. And when they exchanged information with the other representatives of the companies at the meetings, or reached agreements with them, they were doing so on behalf of their companies. After all, it takes hundreds of persons to implement and carry out a conspiracy over the 12-year period for these 22 companies. So what I'm showing you here is a presentation, a demonstrative of the contacts between the companies. The left, you'll see the number, and in the start date is when the meetings or communications occurred. The third column are the attendees at the meetings. And each of these entries is supported and documented by contemporaneous records of the meetings. Now, the defendants produced millions of documents during the span of this litigation. And when we looked through them, we were able to identify over 1,000 of meetings involving these companies. And each line in this spreadsheet is an instance of the communication. And sometimes technology doesn't work.
On that note, are all of your monitors on? Okay, great. Okay.
So if you bear with me a second, I think it's going now. So as I said, each of these lines is a meeting or a communication between the defendants in this case. And in the participant column is a listing of which companies attended the meetings. And as you will see, not every communication involved every company. And some only involved 2, some involved more. Some were telephone calls, some were emails, but some were group meetings, and sometimes more than 2 companies got together. Some of these meetings occurred in coffee shops. Some occurred in bars. Some occurred on the golf course. We know each of them happened. Now, in these conference rooms, in bars and restaurants, and at resorts, or on the golf course, these companies met and conspired. And we will prove to you that this was not by accident or by chance. And when they did meet, and we'll show you what they discussed and exchanged information not as competitors, but as companies working together to increase their profits and to elevate prices above what they should have been. And by going to these meetings and communicating with these other companies, the participants actively participated in the conspiracy and demonstrated their commitment to the conspiracy's common goal and purposes. Now, you will learn that the information exchanged by the conspirators was confidential and not public. It was the kind of information that companies would not share with each other in a competitive market for fear that their rival would take advantage of it. It was also the kind of information that conspirators would share so that they could coordinate and work together with their competitors. Now, these suspect communications occurred in a variety of ways. Now, the Japanese have a word, izakaya, which is the name for the kind of bar or club where Japanese businessmen go after work to drink and to socialize and to talk. Many of these meetings occurred at izakaya. But they also occurred in other places, coffee shops, conference rooms, on the golf course. But they did agree, as this shows, to regularly meet with one another. And we will prove to you from the evidence of and other communications that the conspirators sought to coordinate with each other and to elevate prices. Now, when the conspirators agreed to provide information, they knew from their years of participating in the conspiracy that they would receive information in return, that it would go both ways. In other words, when the companies gave information to their competitors, they knew that they would get similar information back. And as we will show you, companies that are competing and not cheating wouldn't do that. And from the type of information exchange, and we will show you that, you will learn that there was an agreement, there was an understanding. There was something of value being exchanged and something of value being received. And that shows a meeting of the minds. And basically, the agreement was that the companies wouldn't fight with each other, and they would do their best to avoid price competition. Let me describe some of the testimony in the case. Mr. Nishizaki of Panasonic was asked about the purpose of the meetings. And when we asked him, what he said is, the purpose of the discussion was to prevent price reduction in general. That was what the purpose of the meetings were. Now, one key way you will see, as I mentioned, is the conspirators getting together. You can take that down. Is the conspirators getting together to provide each other and share their confidential information. You will learn that competitors do not give up this kind of information unless they know they're getting something in return. There's no give without get. And you will learn the benefit of participating in this conspiracy was receiving information in exchange for what they disclosed, and also an agreement to eliminate competition and to raise prices. Now, some of the group meetings in Japan and Asia were attended by companies that manufactured mostly aluminum and tantalum, but also film capacitors. And other meetings were held by companies that mostly manufactured film capacitors, but also made aluminum capacitors. Other meetings occurred between companies that manufactured all three. But regardless of who or what type of company was attending it, these meetings or communications, and what product they manufactured, all of these meetings concerned capacitors sold in the United States. And you'll learn that you will learn that the representatives, the same representatives of each company didn't attend every meeting, and that some meetings were attended by some and not others. Or that the discussions at the meetings changed depending on what was going on in the world at the time, or what the particular situations were in the market. But all of the meetings, these group meetings, we will show you, shared the same features and subjects. One of the features of the meetings was that they focused on large customers. Some of the large customers you will recognize by name. For example, Intel or HP, the Hewlett-Packard Company. But some of the large customers are based in Taiwan and other places and manufacture products for American companies that you will recognize. For example, the companies that Apple uses to manufacture its products abroad. And these companies had their factories in Asia, in Japan, Taiwan, or Singapore. Now, as you will learn, there are something like 1,800 direct purchasers of capacitors in the United States during the class period. And it was unnecessary for the conspirators to have a discussion about each and every one of them. The conspirators focused on these big companies. And they did so because the big companies were the strongest and largest of their customers. And because they were the strongest and largest, they had the most bargaining power, the largest ability to negotiate a better price. And if the conspirators were able to agree regarding prices to them, the prices to the smaller customers would surely follow. So that is why, as you will learn, the discussions of the conspirators frequently mentioned a few large buyers. Next slide, please. Now, these are notes of a pricing strategy policy meeting which occurred in February of 2003. These are notes of the meeting written in Japanese by Norio Kasuga, a sales executive of the Rubicon Company, who will testify at the trial. And as I showed you, Rubicon is one of the companies that pled guilty. If you go to the next slide. So, as Judge Donato mentioned, you will see translations in this case, and this is an English translation of the Japanese language document that we prepared. And let me point out a couple of things about the document. The meeting occurred in February of 2003, February 4th, 2003. And the place is a hotel in a part of Tokyo, Gotanda. And the participants in the meeting are listed, and Mr. Kasuga, who wrote this, used abbreviations which correspond to the first letter of the company's name in Japanese. So in Japanese, the company we're calling Nippon Chemicon went by Chemicon, and that's why it's C. Others are more straightforward. E is Elna, N is Nishikon, S is Sanyo, F is Fujitsu, which was a company subsequently bought by Nishikon, R is Rubicon, M is Matsushita, which at the time was the name of the company that is now Panasonic. So those were the attendees at the meeting, and as indicated, Matsushita didn't attend. Could you go to the next slide, please? And so at the beginning of the notes, Mr. Kasuga writes down what the purpose was of the meeting, and it was about a price strategy for capacitors. And he also notes why they were getting together in February, on February 4th, 2003. And that's because a few days earlier, on January 29th, 2003, senior members of the company, CEO level individuals or persons responsible for the global capacitor business had met together and agreed that they wanted to come up with a strategy for raising prices. And after they did that, they told their lieutenants, their more junior staff, to get together and implement the agreement that they reached. And these are the notes of that meeting. And you'll see that the two companies that are mentioned, one is Company I in the United States. That's Intel. Company F is a company called Foxconn, which is one of these companies that Apple and others use to manufacture their products in Taiwan. And that's what the reference is to Taiwan. Now, next slide, please. Mr. Kasuga's notes summarize the discussion and the agreements were made. The first section had to do with a water-based electrolytic capacitor, and it generally says that the current price levels are going to be maintained. And as Mr. Kasuga indicated, he understood, based on that communication, or what went on at that meeting, that all companies agreed. Then they also agreed how they were going to handle negotiations with big customers. Intel and Foxconn are big customers. And at the time, in 2003, they were pushing very hard to get lower prices. And so one of the things they had to confront was what to do about that. And what they did is they agreed to limit the amount of discount or how far they would go down when pressed by big customers. And as indicated here, they agreed that that number would be 2%. And as Mr. Kasuga says, all companies agreed. In addition, at the time, the companies were about to introduce a new type of capacitor product. And it was also important that the companies were able to keep prices for that product high. And so what they wanted to do was to come up with a pricing plan which the companies were going to share and join in for this new type of capacitor product coming into the market. Rubicon, Mr. Kasuga, suggested a plan. And as he said in his notes, all companies agreed to R's plan. R is Rubicon. These agreements are clear as day. This is an agreement to fix, maintain, and stabilize prices in violation of United States antitrust laws. Now, what's also interesting about this is that you'll see that it's in red. And when Mr. Kasuga took these notes, he sent them to the others at Rubicon. He sent them to the people responsible for Rubicon sales all over the world. He sent them to others in Japan, but he also sent them to the people responsible for, at Rubicon, for sales in the United States. And he highlighted them in red because he wanted to make sure when those people got that email and received this report, they knew about and recognized and paid attention to this very important agreement. Now, these discussions continued. This is 2003. They continued until until roughly 2013, when they were turned in. Let me show you the notes of another meeting which occurred slightly afterwards. This is August 2003, a few months later. This is another set of meeting minutes. There are different, some of the same companies were there. Some individuals that we've seen in the past were there. Could you show the English, please? So again, we've translated it from the Japanese into English. And you'll see that it's a meeting that occurred in Yamanashi Prefecture in Japan. And it was hosted by the Sanyo company. And you will see the companies that attended the meeting, NEC Token, Elna, Nippon Chemicon, Nishikon, Rubicon, Fujitsu, Matsuo, Sanyo, and Rome. Now, as you will learn, at each of these meetings, one of the representatives of the company had responsibility for organizing the meeting and chairing the meeting. And at this meeting was Mr. Kato from Nishikon, and he's pretty clear about what the purpose of the meetings are. And he says that in this section. The meeting's purpose is to exchange information for each market and capacitor category in order to ensure all makers' profit generation and maintenance of a healthy market price. That was the purpose of these meetings. Now, I'm not going to show you all of the meetings, but the other parts, all of the notes, but the other provisions of this, or the other parts of the minutes, indicate discussions of U.S. customers, for example, U.S. car companies, and which shows that the purpose and target of these meetings was the United States. Now, would you show the next slide, please? Now, I talked a little bit about the kind of information that was exchanged at the meetings. This is an example of one of the forms that was used at the meetings. This was prepared in December 2012, and this is a chart of information from the Chemicon company. Again, that's the name for the company we're calling NCC. One of the features at the meetings is before they started, before there was a discussion, each company made a presentation regarding certain confidential sales information. And let me point out a couple features of this. First, on the left side, it refers to different types of capacitors, aluminum and tantalum, and different subtypes within those categories. At this time, Chemicon made aluminum but not tantalum. Other participants made tantalum and not aluminum, so their charts looked a little bit different. But what they did is they used a benchmark, and that's why it's in percentages. And what they did is they reported on their historic figures, and those are the columns on the left going up to November. And you'll remember, or you'll see that these minutes were in December. And so it also includes future information, what their projections were. And this is here, Nippon Chemicon is reporting on its projections for both volume and revenue. That's what the amount is for December, January, and February, and the following period. The info The information that it was exchanged was confidential, it was highly sensitive, it was past information and future information. Now, as I mentioned, the communications in Asia mainly involved Japanese companies and their representatives. And the meetings there logically took place in Japanese. Now, nonetheless, AVX and Chemet, information from AVX and Chemet was discussed and exchanged. How did that happen? Through the companies in Japan that maintained the strongest relationships with AVX and Chemet. As it happens, that was the NEC Token Company. And in particular, Tomohiro Date, who you will hear about. He was one of the ringleaders of the conspiracy. Let me show you some deposition testimony. Now, this is from the deposition of Mr. Imai of Elna. And as I mentioned a few minutes ago, the companies, the practice was, and the agreement was that the companies would take turns being the organizing company. And the organizing company did things like making arrangements for the room or the resort or the golf course. They booked the location. They arranged for refreshments. But one of the key jobs was to make sure that the companies attending received the information that was part of the agreement. And as Mr. Imai testified, part of his job when he served as the organizing company for the MK meeting, you'll learn that MK is the Japanese abbreviation for market research. Some of the meetings were called MK meetings. He acknowledges that one of the jobs as the organizing company was to make sure that all the companies attending received the information. The next slide, please. Now, Mr. Imai also testified that it was typical that NEC Token provided information from AVX and Chemet at these meetings. And the reference to NEC is a reference to the NEC Token Company. And so we will show you that Mr. Date from NEC Token was a frequent attendee at the meetings and communicated outside the meetings and exchanged confidential information and reached agreements on prices with competitors. We'll also show that Mr. Date met in Japan with representatives of AVX and Chemet. And you also see that shortly after the meetings between Mr. Date and AVX and Chemet, that when you look at the minutes of the group meetings, NEC Token was discussing and disclosing AVX and Chemet's confidential information. Would you put up the next slide, please? Now, we also took the deposition of another executive from Elna whose name was Shin Kinoshita. And he talks about this information. And he confirms that, one, information regarding AVX was disclosed at this meeting, and that, two, the companies that were receiving that information found it important and useful in making their business decisions, including prices. So despite the fact that AVX wasn't inside the room speaking in Japanese, their information was very much part of the exchange of information at the Japanese meetings. In addition, we will show you that AVX and Kemet were frequently communicating with each other and coordinating their own efforts regarding prices. Next slide, please. This is an email from a Mr. Robbie, who worked for AVX in the United States. And we know that because his email address indicates AVX US. And this happened in April of 2004. And he reports on some discussions he had at a business meeting. And the first is a discussion of Kemet. And he reports that when he met and communicated with Kemet, they reported to him what their pricing plans were in the future. That prices were going up 5 to 15%. That's price fixing. And he also indicates that he was also meeting another company, Vishay, and that he was going to go out and have a couple of beers. And he talks about it being a social hour, but you can tell from the email that it wasn't just social interaction that was on his mind. This kind of behavior is collusion. It's not competing. This is price fixing. Now, you will also learn that AVX met with the Chemicon company. Now, the Chemicon company had an entity in Japan where its headquarters were located, which went by the initials NCC, Nippon Chemicon. They also had a wholly owned subsidiary in the United States called UCC. They also had a subsidiary in Europe called ECC, Europe Chemicon. And at a meeting between AVX and NCC, they discussed how they would arrange to work together and not to compete against each other. And as it happens, NCC was represented by one of its company's board of directors, a very senior executive, as well as the CEO of UCC and ECC, which happened to be the same person, and also AVX's top executives. And at that time, both companies had plans to sell capacitors in the United States. But what they discussed at the meeting was the fact that they want to get along and not hurt each other through competition. Now, AVX also met with Japanese manufacturers in Europe and in Japan. AVX met with Kemet in places throughout the world. As I said, AVX met with NEC Token frequently in Japan. And at those meetings, they exchanged information. Now, you'll hear testimony from a gentleman named Peter Colas, who was one of the people running AVX's global sales. He went at least once a year to Japan, and he communicated with many Japanese companies there. You will also hear testimony from AVX salespeople who met with Sanyo, Kemet, NEC Token, Hitachi, Rubicon regarding US purchases. And in addition, as we will prove, there were dozens of communications between AVX and Kemet. These occurred in the United States, where the two companies are headquartered, but also in various parts of the world, including Mexico. Also, we will prove that the companies involved in the conspiracy knew what they were doing was illegal. They knew it was price fixing. They knew it was not permitted. And we will prove that by showing you the evidence of the steps the companies took to conceal their activity. You can tell that from the numerous emails that say something like, destroy after reading. As you will learn, this is conduct to cover up and conceal what they did, which is proof that they knew what they were doing was wrong. Could you put up the next slide, please? Now, this is an internal Rubicon email in May of 2008. And you will learn that 2008 was a period where a lot of these communications happened because of what was going on in the world at the time. There was the Lehman bankruptcy, and the demand for products went down, but also afterwards, the economy turned around, prices started to go up, and you will see a lot of evidence about the efforts of the companies to stop the prices going down in 2008 and turning it around and trying to raise prices in 2009. So this is an internal email from Mr. Miyashita, and he reports on a meeting that he had with 5 companies shortly before he wrote the email. And the 5 companies are Nippon Chemicon, Elna, Hitachi, Nishikan, and Rubicon. And he notes in the beginning of the email the purpose of the meeting, and he says it was a price restoration meeting. It was held today between 5 of the companies within the industry. And you will learn that price restoration means raising prices. Next slide, please. And then he also describes the agreement that was reached and how it was going to be implemented. It will proceed in a top-down manner. That means from the senior executives making an agreement, and then a junior sales managers meeting will be conducted separately to implement and to effectuate the agreement. But then he closes his email with the note, please discard after reading. That's because they were price fixing. Now, defendants may argue in this case that there was no conspiracy because they can identify a few isolated moments where one company negotiated a lower price or tried to take a little business from one of the other companies. But the fact that there are some points in time where that happened doesn't mean that there was no conspiracy or that the conspiracy was not effective. We allege a global conspiracy over a 12-year period. And we will show you that that conspiracy generally elevated prices. That doesn't mean that prices never went down or that one participant tried to get a little more business from time to time by lowering its prices to a particular customer. In fact, sometimes cheaters cheat. And they tried to take advantage of their agreement to their own benefit. But in fact, that's why the companies met regularly, to meet every month, and to make sure that companies were following the agreement, and to make sure that they were taking steps to monitor what the other companies were doing, and to make sure no one was cheating. In addition, we are going to be presenting to you testimony from experts. And the experts will show you that the information exchange was anti-competitive and that it was the method the defendants used to raise prices. Now, economists that have looked at this subject have looked at it many times. And when they did that, they learned or concluded there are ways to distinguish communications which are consistent with competition, and those which are inconsistent with competition, or in other words, consistent with collusion. To distinguish between communications which on one hand are competitive, and on the other, communications which are not. You will hear testimony from an expert economist named Dr. Hal Singer. Singer is an economist with a PhD from Johns Hopkins University. His expertise as an economist is in antitrust economics and the study of competition and competitive markets. He is the kind of economist who studies competition and collusion and price fixing. He is an expert at how some types of communications are consistent with competition and some which are inconsistent with competition but consistent with collusion. He's also an expert on determining the effects of an antitrust conspiracy. He will explain from the perspective of an economist how competition should work and what happens when it doesn't. Now, economics focuses on incentives. For example, how does a company choose to set its prices? Singer studies the workings of industries, including companies that compete with each other. Now, economists are like detectives. And just like a detective uses or solves a case with tools or clues, economists do something similar with economic tools and economic data. And by applying these tools, they can do useful things.
It's just spent about over an hour. How much longer do you have?
I'd probably be done in 10 minutes.
Okay, thank you. Just checking in. Go ahead.
I'm sorry. So we asked Dr. Singer to apply the tools of an economist here. Could you put up the next one? Cartel investigation that are recognized in his field of economics. And in particular, he looked to identify communications that had certain characteristics that economists identify as consistent with collusion, or in other words, inconsistent with competition. And one was the sharing, or is the sharing of price or output information. The other is current monitoring or future planning. And Dr. Singer, using that criteria, examined the records in this case, and he found dozens, if not hundreds, of meetings and communications that, consistent with this economic criteria, showed acts consistent with conspiracy. For example, the information exchanges were about price and input, price and the costs of inputs. The information that was exchanged wasn't only about the past, but it was about the future. And the information was not summarized or aggregated. So the companies exchanged the information directly between them, as opposed to between a third party. Even one instance of communication like that is anti-competitive. Genuine competitors don't provide their competitors with that type of information. Genuine competitors don't provide their competitors with the smallest details regarding their business. Not yearly, not monthly, not weekly, and certainly not future information. And as we will show you, the records in this case show that these communications are not the activity of companies competing with one another, but they instead are the acts of companies united in an agreement to raise their profits and raise the prices to their customers. Now, Dr. Singer will explain that one of the key features of the conspiracy was the agreement and understanding to enter into this information exchange. And the fact that it was reciprocal meant that the companies knew that they were receiving information when they were providing it. And Dr. Singers conclude that companies that are competing with one another do not do that. And the evidence will show that these types of communications occurred hundreds of times. The last step in our proof or our analysis will be the proof of the effect of the conspiracy on prices and the damages caused by defendants when they violated the antitrust laws. My clients purchased billions of dollars of capacitors during the period. On this subject, you'll hear from an expert whose name is Jim McClave. Dr. McClave is an expert statistician, and in particular, the type of statistician that focuses on antitrust cases and antitrust economics. Dr. McClave literally wrote the book on this subject. Statistics allows us to determine whether the defendants elevated their prices and make that determination in a scientific way. Dr. McClave's field, econometrics, involves applying statistics in an economic setting and doing that sort of analysis. First, Dr. McClave will conclude that the conspiracy elevated the prices of aluminum, film, and tantalum capacitors. He did that by looking at over 7 million transactions. He looked at all the data we had regarding the transactions in which the defendants built or delivered capacitors in the United States. He concluded, based on that analysis, that the conspiracy in fact raised capacitor prices higher than they would have been if it hadn't been for defendants' illegal conduct. Now, second, Dr. McClave measured the amount by which my clients were overcharged. He did a calculation, and I'll take a moment to go through each, but we're looking at aluminum first. He did it for each type of capacitor, aluminum, film, and tantalum. Dr. McClave's analysis is complex. He applied the factors that econometricians or statisticians have identified for determining whether a conspiracy has had an impact on prices. The test Dr. McClave performed confirmed that analysis. He was able to isolate the effects of the conspiracy from other market conditions. And he tested it in dozens of ways, which we will show you. Now, you may hear from the other side's experts. They criticize Dr. McClave. But they never do the analysis to support their criticisms. Dr. McClave listened to the criticism. And what did he do? He tested his analysis again. And he looked at each of the factors and he, like switches, turned them off and on and tried to determine how that would affect his model and his calculation. And when he did that, that exercise confirmed his conclusions. You will learn, as I've indicated, that my clients purchased over $5 billion in capacitors during the class period. You will also learn the calculations Dr. McClave performed to determine the amount of damages caused. There's some complexity to the math, but in some ways it is really quite simple. The first thing he did is using the sales data, determine what the actual price was that the defendants charged for the capacitors. And he did that by looking at all the prices in the data over the period of the conspiracy. And we've shown that with the red line on this chart. Those are the prices of aluminum capacitors during the relevant period. And then, using his methodology, which I described, he determined what the prices would have been without the conspiracy. And that's the blue line. And the blue line is lower than the red line, which means that the prices that would have been charged if there hadn't been the conspiracy are lower than what were actually charged. And then Dr. McClave did a calculation of the difference. And the difference is the shaded red part, which is the difference between what they paid and the lower price they should have paid. And so for aluminum capacitors, he determined that my clients were overcharged approximately a little over $240 million for aluminum capacitors. He calculated an overcharge, a general overcharge over this period of 8.9%. And then he did it for film. And for film, the total overcharges is a little under $22 million. And the overcharge percentage for that entire period is 6.6%. And then he did it for tantalum. And he calculated that the overcharges for tantalum are a little under $165 million and an average overcharge of 7%. Next slide, please. So then Dr. McClave added it all up. And this shows you his addition. He did it by each capacitor type. He shows the revenue for each capacitor type during the class period. As I said, the total is a little over $5,392,273,311. And then applying those overcharges, he calculated what the damages are. And the damages Dr. McClave calculates are $427,530,613. Those are the damages to my clients in this case. Members of the jury, thank you very much for your time. We are going to prove in this case that these defendants, together with their co-conspirators, agreed with each other to restrain, prevent, and eliminate competition. They agreed to do so with the purpose and effect of raising and stabilizing prices of capacitors in the United States. They did that by agreeing to exchange confidential information. And they did that so that the other companies would know their plans and intent. Why did they do it? To avoid reducing prices. They did it to keep their prices high and to make sure their customers, my clients, paid more than they should. Plaintiffs' money damages will fix the consequences of this harm. At the end of the trial, after you hear all the evidence in this case, I'm confident that you will conclude that the defendants agreed to share their confidential information and agreed to restrain competition and elevate prices to my clients in the United States. The antitrust laws are designed to protect competition. And as it happens here, the defendants destroyed competition. They destroyed competition when they agreed to exchange this information and they agreed to coordinate on prices. They did that when they agreed to share their plans with the others. They did it when they tried to avoid companies reducing prices. They did it to keep their profits high, to make sure my clients paid more than they should have. It is time for them to compensate those that were injured by this. At the end of the case, I will have another opportunity to speak to you. And at that time, we are going to ask for a significant verdict to compensate my clients for the damage that's been caused. Substantial damages are warranted in this case, and we will ask for a verdict in that amount. Thank you very much.
All right, we're going to take our afternoon break a little bit earlier than usual, but we'll take 25 minutes, or 20 minutes, and then we'll hear from the defendants.
All right. Please be seated. We're back on the record in Civil 14-3264 and Multi-District Litigation 17-2801, in-rate capacitors antitrust litigation.
Okay, now we'll hear from the defendants, and I think there'll be, because there are separate defendants, separate speakers. Okay.
Thank you, Your Honor. May I proceed?
Yes.
Good afternoon, folks. I will confess that standing or sitting at my chair for the hour and a half that class counsel spoke was difficult for me. Not difficult because we don't have answers to the questions we raised. Not even difficult necessarily because we disagree with everything that class counsel says. But it's like, I guess, for me, when I'd get into a fight with my sister and we'd disagree and we'd go to our parents and start talking and they'd say, stop, one at a time. And the way it works here is we go one at a time. So Mr. Severi got to speak, and now it's our turn to speak. I suppose I should go back and reintroduce myself. My name is Roberto Finzi, and as I indicated when we met briefly this morning, I represent NCC, or Nippon Chemical. Here in the courtroom with us is Mr. Takahashi Nakamura, who has come from Japan to be the representative, and he'll be here for the trial. Before I talk about NCC in particular, I do want to say a couple things about the defense as a group. And in particular, what I want to say is that although we're all at the same table and referred to as defendants, it's really 4 different companies. And we don't want you guys to think that this is plaintiffs versus defendants, plural. You'll hear that these are different companies located in different places that make different products, organized under the laws of different jurisdictions, and that frankly function in their own ways with their own corporate personalities. And you'll hear that as the evidence comes in. You'll see and hear that evidence as it comes in, how each company differs in terms of their markets, in terms of their products, in terms of how they sell, in terms of how they're structured. But there are some things that all of the defendants agree on. And I want to focus on those for a minute first. And what all of the defendants agree on is that plaintiff's case here has been dramatically overstated. And what I mean by that is this. And hopefully everybody's monitors work. Okay. You will not hear a disagreement from the defense, although different people will put it different ways, and you'll hear again different arguments, that there was an illegal agreement by certain defendants to set prices for certain capacitors sold to certain class members. There will not be a legitimate dispute about that. You will hear some of the defendants dispute whether they were part of that conspiracy, but there will be no dispute as to the existence of the conspiracy. The dispute, and what the evidence won't show, is the extraordinary allegation that the class has made about the size and scope of that conspiracy. Because what they have done is taken a case involving certain defendants, certain capacitors, and certain class members, and turned it into a conspiracy that involves every single aluminum, tantalum, and film capacitor made by every single defendant, 22 of them, not just the defendants that are sitting here, but 22 of them, sold to every single class member, 1,800 of them, for a period of 12 years. And that, ladies and gentlemen, you're going to see in the evidence, is an overreach. One way of looking at it is the following. And this sort of illustrates more graphically with specifics, the point that we're making. I'm sorry, mine, we're good? Okay. These are the companies that enter the guilty pleas, and we'll talk about those. There's 8 companies, and we added in there Panasonic, you see with an asterisk. That's the amnesty applicant. But these are the companies that admitted their guilt. They are Japanese electrolytic manufacturers, and they admitted their guilt. This is what plaintiff's counsel is asking the class to be compensated for. So what have they done? They've enlarged this circle. They've enlarged the circle in 3 ways. First, they've added defendants. Second, they've added capacitors that don't belong there, capacitors that are not electrolytic capacitors. And third, they've added sales to class members that are not affected by the conspiracy. So for example, in talking about the defendants, they start with this group, and you'll see some of the defendants here. Nippon Chemicon, that's one that pled. Matsuo, you'll hear from them in a little bit. That's one that pled. But they've added others. They've added other Japanese electrolytic manufacturers. Ladies and gentlemen, look and listen to the evidence. Look at all the documents you were shown. Look at them carefully. You will barely see these names mentioned. What else do? They add in defendants who make only film capacitors, film-only capacitors. None of these defendants pled guilty to anything. You will not hear a word about a guilty plea for these defendants in the case. And finally, they've added American manufacturers. And there are 2 here today, AVX and United Chemicon. And so what they've done is taken a core of a case and in 3 ways blown it up. And the reason they've done that, and you'll hear evidence about this, is frankly not very complicated. It's because by adding all those products and all those defendants and saying that every single capacitor was sorry, I got that for you, so you can't see. They've massively inflated the damages that they're claiming. This is the box, the circle of defendants that pled guilty. These are the damages that they're seeking based on sales of those defendants. And I don't want for a second to say that all of these were in fact affected sales. The proof is not going to show that. I'll get to that in a minute. But what they've done by adding the film capacitors, by adding AVX, by adding Chemet, by adding the American companies, is doubled the amount that they'll ask you for. And the proof will not back it up. A word quickly on capacitors. You heard some of this from class counsel, but it's important to this point that I'm making about defendants and what the proof is going to show about the number of defendants. Remember, there are 4 defendants in this case at the table, but there are 22 defendants that have been sued. The damages that they are seeking, the proof is going to show. You'll see the economic calculation. There won't be any doubt about this. The damages they are seeking are based on all sales of all electrolytic aluminum, tantalum capacitors to all of the members of the class. So there's 4 defendants at the table, but they sued 22, and those are the damages they're seeking. And what do we know about the industry, or what are we going to learn? We're going to learn that capacitors come essentially in 2 shapes and sizes, or basically 2 forms. You have electrolytic capacitors, and you have electrostatic capacitors. Electrolytic capacitors, in turn, are divided between aluminum and tantalum. You don't need to know the details. We'll learn it all as the trial goes on. But just wanted you guys to be familiar with the terms. There's also film capacitors, which is a type of electrostatic capacitor, and then there's ceramic capacitors. And the only type of capacitors that are not in this case, is the ceramic ones. So they have added in, the proof will show, manufacturers of aluminum, tantalum, and film capacitors. Now, what's helpful to know about these capacitors, and you'll see evidence of this, you'll hear about it, is that capacitors come in all different shapes and sizes. You heard that they're in virtually every electronic product, and that's right. The capacitors can be as small as half my fingernail and cost less than a penny. Imagine a product that costs less than a penny. That if somebody said, I'll give you a penny for it, you're overpaying. They go from those to products that are as big as trash cans, as big as cans, and that fit in enormous vehicles. You'll hear that there are products that go from everything from the smartphone, this probably has capacitors in it, the clicker I use, to the space shuttle, to the Mars rover. And obviously what that means is capacitors need to be different. There's some that, what's okay for an Xbox is not okay for a heart valve. And the point is there's literally dozens of different manufacturers of literally thousands, tens of thousands of different capacitors, all of which are different. This is not like gasoline, where there is a price for gasoline, and whether you get it at Texaco or you get it at Exxon, it's the same. Many, many different products made by many, many different people. And with respect to some of these defendants, for example, film, this is where we are on the chart here. These are the additional film defendants that were added in, none of whom you'll hear any evidence of guilty plea on. You'll hear that there were no guilty pleas by any of those. Still, they're claimed to be part of the 22 company conspiracy, and you'll hear that they didn't even show up at the meetings involving electrolytic capacitors. These meetings, which is what you're going to hear 95% of the evidence of, look at the notes. Listen to the witnesses. Folks, we embrace this evidence. We embrace the evidence. Look at it and look and see if you see film capacitors present at the meetings that you heard about from the class. You won't. That's just another way of making the pie bigger, because if the pie is bigger, the slices are bigger. What else? What's another way that they try to expand this class and the damages? Another way they do it is to talk about sales. Now, again, this is not like gasoline. Gasoline, at least for consumers, it's the same. You pull up, you pump your gas, and you go pay. Maybe you pay cash, maybe you pay in credit card. But it's simple, right? Pull up an order. The way capacitors sold, and this makes sense based on what you heard about how capacitors are made and how they function, are done in very different ways. There are some, a super special capacitor that needs to go into a Mars rover or into somebody's heart. You don't buy that off the shelf. That's an engineer from the buyer goes and talks to an engineer from the seller. They sit down, they talk about the specifications, This one needs to withstand temperatures of up to 125 degrees. This one needs to be small enough to fit into something that's going to orbit space. This one needs to last for years. This one doesn't. So it goes from the cheap penny ones to big ones. But the big ones, your common sense and the evidence will tell you, are not sold off the rack. And so the prices for those you can't fix because they're agreed on by negotiation. Plaintiff's class includes these made-to-order capacitors. Second, and again, this is common sense, you have catalog sales. Let's say NCC comes out with a catalog in 2001, or 2000, before the class period begins. And that catalog remains operative, and you'll see evidence of this, for 3 years. And in 2003, somebody goes, a member of the class goes and orders something out of the catalog. Well, that price hasn't been fixed. Conspiracy didn't start till 2001. And yet they purchase it out of the catalog for the catalog price. Again, folks, and I want to be crystal clear here. Nobody's saying that no prices of any capacitors weren't fixed. We acknowledge that. I'll come back to it in a second. And by we, I mean NCC. Other defendants are situated differently, further to my point of not all defendants being the same. But it cannot be the case that a product purchased from a catalog in 2001 was affected by a meeting that happened in 2002. And it can't be that a product purchased from a catalog that's dated 2006 is affected by a meeting that happened in 2008. That just doesn't make sense. And finally, and again, these are contract sales. There are contract sales which plaintiffs have placed in their class. And what that is I enter an agreement with you that says for the next 3 years, you're going to sell me this kind of capacitor at $10 each. And we have a deal. That's going to be the price for the next 3 years. Well, if that's the price we've agreed to, and if I deliver based on that price for the next 3 years, how can any agreement that I reach with my competitors affect that price? It can't. And again, I want to be very careful in saying what the proof is going to show. We are not saying that there weren't agreements to set prices for certain capacitors by certain defendants involving certain sales. We acknowledge that. NCC acknowledges that, and I'll come to that in a minute. What we are saying is that by drawing this circle so large, they have alleged a conspiracy that the proof does not support. The conspiracy that they have alleged is bigger, broader, longer, involving more products and more plaintiffs than what the proof is going to show. Another way that the pie has been made bigger is, again, by including every sale of every tantalum film capacitor to every single class member. Well, what's the proof going to show about that? And again, we ask you to pay attention to it. It's going to show that a huge amount of the sales, something like 19%, the numbers will come out in the proof, were only made to film capacitors. So, 19% of the sales, let me put it the other way, 19% of the class only purchased from film capacitors. That means that their only purchases, never bought from any of these, only bought from these. Their only purchases are from film capacitors. The film capacitors who the evidence is going to show did not plead guilty and didn't go to the meetings. They went to film-only meetings, separate meetings. And if you conclude that film is not part of the class, that takes out 20%. What else? The US companies. You'll hear from those. The US companies, again, account for an enormous amount of the sales. So this is another way of just making the pot bigger. And finally, and I don't want to leave any doubt about this in terms of what the proof is going to show, this part, what's orange on the chart with caution, this is not what's conceded. This depends on every sale of every capacitor to every class member. Forget about these. The evidence is just, you'll see the evidence about who went to the meetings. These are American companies, don't speak Japanese, weren't in Japan, weren't at the meetings. There's just no question about that. You'll hear from United Chemicon in a second. But even this part involves this incredibly overbroad set of sales, overbroad set of defendants, overbroad set of capacitors, overbroad set of class plaintiffs. So let me go back now and talk about NCC in particular. And I want to start with the plea agreement because it's important. And it's important for two reasons. First, it's important for what it says. And it's important because it shows that NCC came into court and pled guilty and acknowledged misconduct. It's not very often that lawyers stand up and acknowledge that their clients engaged in misconduct. It's certainly a first for me. But that is what the evidence will show. It's what the evidence has already shown because this is already evidence. And what does it show? What it shows is that NCC came in and pled guilty to price fixing. And that's important. No matter what we say, no matter what we do in this trial, I want to be crystal clear that NCC is not walking away from that. NCC acknowledges that it was involved in conduct that it shouldn't have been involved in. But what else does the plea say? Or more importantly, what does it not say? And this is where words matter. Three things. First, it refers to a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids of certain electrolytic capacitors. Remember, what the class is charged in this case goes way beyond electrolytic capacitors and includes manufacturers of film. That's not in the guilty plea. What else? The language, and it's very specific and it's in evidence, says certain. It doesn't say all, it doesn't say every, it doesn't say every sale to every class member. The language matters. This is evidence. You are entitled to look at it, to study it, and to understand it. And to look at this is to see that this notion of all capacitors, the whole circle, whatever it's supported by, it's not supported by the guilty plea. And finally, with respect to NCC's plea, it specifically says and refers to capacitors manufactured outside of the United States. Well, what does that mean? The capacitors that AVX makes in the United States, the capacitors that Chemet makes in the United States, the capacitors that United Chemicon, which is Nippon Chemicon's subsidiary in the United States, those are not part of that plea. Whatever evidence you're being asked to rely on to make that finding, it is not in the plea. You will not find it there. Let me step back real quick and just tell you a little bit about NCC so you've got some context, and this falls into the category of each defendant being a little bit different. NCC goes back 90 years. It's headquartered in Japan. It employs about 1,000 people there. This goes to the point I made before about the extraordinary number of different capacitors it makes. Like I said, you'll hear evidence that the ones that NCC makes in particular, go from tiny and costing less than a penny to, enormous and costing $10,000 or more, maybe even $40,000. I can't remember the exact number. And let me very quickly, although you will hear from the lawyer for UCC, let me very quickly describe that. UCC, United Chemicon, is a subsidiary of Nippon Chemicon, but it is a separate company. It is organized under the laws of the United States. It's got its own operations, it's got its own products, it's got its own customers and clients. And again, you'll hear later this afternoon from counsel for United Chemicon who will describe that in more detail. And what will the proof show about Nippon Chemicon and its agreement with others to fix prices? you heard a lot of references to these meetings. And the point here that we ask you to keep in mind and look for very carefully in the evidence is that not every meeting is an agreement to fix prices. The list that you saw that scrolled through was every contact between competitors. Every contact between competitors is not illegal. There are instances if somebody from NCC calls somebody from Matsuo and says, let's go get a beer or let's go get a round of golf this afternoon, it's on plaintiff's scrolling list. That's just a contact. It does not mean that pricing was discussed. It does not mean that pricing was agreed to. It's just a contact. So we ask that you be particularly careful in looking at the meetings. And look, guys, flat out, and be honest, you're going to see some meetings that very clearly refer to price fixing. For certain products, that's what's in the plea, involving certain customers. What we ask is that you not lose sight of what is being asked of you. You are being asked to compensate an entire class for purchases of every capacitor sold by every one of the 22 defendants to every member of the class. And you will not see that in the proof. Here's one example, just one. And again, you'll see so many meeting minutes, I promise we'll all be sick of them together. But this is one example of one of the meetings. This one's from February 2012. What is being discussed here, and you'll see the whole document, but you'll see a lot of these discussions, this isn't sensitive, secret information. Industry trade groups are allowed to get together. San Francisco is a convention town. Right now at the convention center, there are industry trade groups that are meeting. And again, I've said this 3 times, I'll say it a 4th. This is not to defend every meeting. We are not here to defend every meeting. We're simply here to make the opposite point, which is not every meeting is a price-fixing meeting. Not every meeting resulted in an agreement to fix prices for every capacitor sold by every defendant to every member of the class. And finally, and I'm just about done, so bear with me for just a couple more minutes. One other way that plaintiffs have sort of enlarged or sought to enlarge the pie is to ignore the fact that there was clear competition between these manufacturers. Not always, not for every product, not every time. Again, that's in the plea. Certain products, certain defendants, certain members of the class. But you will hear, and this is just one example, Mr. Kakazaki is a longtime employee of NCC. He'll be testifying in this trial likely next week. And he's in a little bit of a unique position, both because he's been in the industry so long, with NCC so long, and because he's spent time both in the US at United Chemicon as the president there, and because he spent time at high levels in sales at NCC in Japan. And he will tell you, and you will see documents that reflect the competition. Remember, under plaintiff's theory, every capacitor sold by every defendant, every capacitor of the right type sold to every defendant, every member of the class is inflated. Well, let's see what the evidence shows. And for this is just one example. You'll hear others. I'm just trying to make a point here, what the proof will show. The proof will show that in March of 2011, Japan suffered a horrible earthquake, a devastating earthquake. I mean, we know earthquakes here, and we know what a 9.0 earthquake is. It was among the most catastrophic natural disasters that ever occurred, or at least on record. It killed 20,000 people, but more importantly, for the purpose of this case, it decimated NCC's factories. NCC's factories, just by chance, or as bad luck would have it, many were located in eastern Japan, which was the epicenter of the earthquake. And you will see Mr. Kakazaki himself issues 3 weeks after the earthquake, issues a damage report and says very clearly that they're taking measures to restore the factory, that it'll take up to 3 months to start the operation, and continue to undertake necessary actions. Frankly, he'll tell you that at the time, given the level of the disaster, the main concern wasn't getting the factory up and running. It was helping people the way we do in times of a national emergency. But you'll hear that there was this devastation and the effect it had on NCC and its sales. And so you'll see that by October, and this is a memo prepared by Mr. Matsuzaka, and again, you'll hear about it from Mr. Kakazaki, because it was done at his request. We're now, 6 months after the earthquake, and what happened? NCC's competitors went out there and went on the attack. And they told customers and they told clients, NCC is done. If you need product in the future, you are not going to get it from them. They may never get their factories up and running. They were competing for that business, and in competing for that business, they were telling clients, and you'll hear about this, that NCC was not going to be able to meet supplies. And if you're a producer, if you're a manufacturer of an Xbox, you need that supply. You need constant supply, or else your factory closes too. And so you'll hear that others went out and competed on that. And you see it stated clearly here, the current market situation is quite slow. Chemicon's production in Japan was already recovered in May. So between March and May, they recovered, production recovered, but our order intake is not recovered yet. And you'll hear that NCC lost about 8% of its market share. And that they primarily believed that it was Nichicon that was out there getting that market share. And so they say very clearly, in case of competition, in case of competitors, clearly Nichicon, let's beat them. Let's compete with them. But not just let's compete with them. Remember, the allegation in this case is that there wasn't competition for 12 years among 22 manufacturers of particular kinds of capacitors. And what does Mr. Kakazaki, he goes by Kaki, Japan, what does he say on November 22, 2011? He says, the budget must be achieved. I ask you to generate sales with no upper limit. Go ahead and get them, even if prices are revised for the sake of recovering market share, having received permission from the head office and department head. The point here, again, is not to say that you won't see evidence of illegal price fixing. You will. NCC has pled guilty to that. You will see meetings from documents where there are agreements. The point is that it did not continue and it did not exist unabated for all products by all of these defendants for 12 years. A document like this shows you that that is just not possible. So, in a minute, I'll sit down, and what you'll hear next is from the lawyers for the other companies. You'll hear from Ms. Lau next on behalf of Matsuo. You'll hear from UCC's counsel. You'll hear from AVX's counsel, and then you'll hear a discussion about the damages that are being claimed in this case. Some thoughts about the plaintiff's model in terms of their class and how it was calculated and what we think are some defects there. But before I sit down, let me ask you to do 3 things. The first one is pay attention to the evidence. I have said before, I will say it again, we embrace this evidence. There is bad evidence for NCC, but it proves what NCC did and it proves what NCC didn't do. Pay attention to the evidence and the absence of the evidence. Second is follow the judge's instructions. The judge will instruct you on the law. He has already to some extent, and what he says goes. When there is discussion about the antitrust laws, about what they cover, about what they prohibit and don't prohibit, his instructions are what you need to follow. And finally, and maybe most importantly, use your common sense. We have asked you to sit on this jury because all of you have common sense. the ordinary person, everyday common sense. And if you do those three things, if you listen to the evidence, if you follow the judge's instructions, and if you use your common sense, you will return the only verdict that's consistent with the evidence and the absence of evidence in this case. And that verdict is that the conspiracy that existed is not the conspiracy that the plaintiffs have charged. Thank you, ladies and gentlemen.
All right. Yes, please.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. My name is Bonnie Lau, and together with my colleague, David Cross, we represent Matsuo Electric Company Limited. And today we have here with us from Japan, Masami Oishi. She's a little bit trapped behind the board, who's joined us on behalf of the company. First, thank you so much for serving on this jury. Thank you so much for taking the time, keeping an open mind throughout this trial, and giving me the opportunity to tell my client's side of the story before you make this very important decision. I'll use my brief time with you here today to tell you a little bit about Matsuo and what we think the evidence is going to show. I'm going to tell you the places where we agree with the plaintiffs. But I'm also going to tell you the places where we think plaintiffs are being unfair and they have overreached. So let's start with the company. Matsuo is a small Japanese manufacturing company. It's headquartered in Osaka, Japan, and the bread and butter of the company is making and selling tantalum electrolytic capacitors. Matsuo makes 70% of its capacitor sales to Japan and 90% of its sales to Asian markets. Now, you heard class counsel this morning say that Matsuo participated in illegal price fixing. That's true. It was wrong, and we took responsibility for what we did. However, what plaintiffs' counsel described this morning is very different and much broader than what Matsuo actually did. So you heard class counsel this morning. He wrote on a notepad, this was a broad, sweeping conspiracy, right? He said it lasted for 12 years. He said it incorporated 3 different types of products: aluminum, tantalum, and film. And then he said there were 22 different companies involved. He said maybe 23, but probably 22. Okay? This is a very different conspiracy than the conduct that Matsuo actually engaged in. Different than what it pleaded to, and we think very different than what the evidence is actually going to show. It's going to be very important to pay close attention at trial because no witness is going to testify to the existence of this sweeping conspiracy. No witness is going to testify that that person agreed to fix prices of all capacitor types with 22 other companies for the entire 12 years. So let's start first with what Matsuo did wrong. As I mentioned a little bit earlier, Matsuo pleaded guilty. So did one of its employees, Satoshi Okubo, because of the conduct that he engaged in at Matsuo, and while he was with a different second company, Elna. You're going to hear from him at trial, and he's going to explain to you exactly what he did wrong. And one of the documents that he's going to show you is this one. This is a memo about a price-fixing agreement. And what you're going to see is that it was narrow very specific, down to the last detail. And they agreed. He spoke one-on-one with a competitor company called Holy Stone in the summer of 2010 and said, we agree to fix prices for specific Japanese customers and for very specific tantalum capacitors. And he was very detailed. He wrote down exactly what they agreed to and exactly what they discussed. And here's what it looks like. He said, we agree to fix the prices that we're going to charge to a specific Japanese customer called Calsonic Kansei. And this agreement that they reached applied to 7 types of tantalum capacitors. They're all listed here. Now, I realize 7 might sound like a lot, but the defendants in this case produced over 140,000 types of capacitors. So here they talked about 7. And Mr. Okubo is incredibly detailed. He writes down the exact voltage. Do you see that 10V there? Right, so he writes down the exact voltage, the exact capacitance, the exact case size that this narrow, specific price agreement applies to. Now, during the trial, he's going to walk carefully through this memo with you. He'll tell you that they talked about 4 other Japanese customers and a few other specific tantalum capacitors, each time in this level of detail. And Mr. Okubo is going to explain to you that this is how price agreements were reached on the limited occasions when that actually took place. Specific customers, specific products. Not some general, overarching agreement to raise all prices for all capacitors to all customers. Now, I don't want to sugarcoat it. This is illegal price fixing. It was wrong. And this is one of the reasons that Matsuo and Mr. Okubo took responsibility for their actions and entered into a plea agreement. And in the plea agreement, Matsuo admitted that it participated in a conspiracy among manufacturers of electrolytic capacitors, the primary purpose of which was to fix prices and rig bids, and this is the important part, of certain electrolytic capacitors. Not all capacitors, and no film capacitors. This agreement and the others that you will see at trial, they're narrow and focused mostly on customers in Japan. And that's really important, right? Because we're here in US federal court talking about what are the sales to US customers. And so this case is not about what happened to Japanese customers or sales in other parts of the world. And you are not going to see a single memo like this for any Matsuo customer in the United States. And as you can see, Mr. Okubo and Matsuo, they were willing to write down their price agreement, capturing it in a memo like this one, on the occasions where a price agreement was reached. So why were they so specific when they talked about these capacitor types? Mr. Finzi for NCC, he talked about this a little bit. So there's, hundreds of thousands of capacitor types. And even just among tantalum capacitors, they're each unique. They're designed for a specific purpose or function. And so that means that they're not interchangeable. They don't necessarily compete with one another. So what does that mean? It means essentially that you can't just take a capacitor out of a laptop and then just plug it into a smartphone. That's not the way these products work. And that's why no one is going to testify to this broad, sweeping agreement to fix the prices of all capacitors because they're each different from one another. And because of that, the plaintiffs are not going to be able to show here that all 1,800 purchasers in the United States were each overcharged for the capacitors that they purchased. Now, Instead, the class plaintiffs are going to turn to, in the absence of a witness, these documents regarding the monthly meetings. And they're going to claim that there was something improper about these companies getting together every month, just like a trade association or an industry meeting, to discuss and exchange information about market trends. As the evidence is going to come in, though, you're going to see dozens and dozens of these meeting minutes. And unfortunately, these types of information exchanges, they're not going to be sufficient for class counsel to demonstrate the scope of this conspiracy that they would like to be compensated for. So this is one of the examples, and this is a document that was on their scrolling list of contacts, right? So the sorts of information exchanges that they would engage in look like this. The companies would talk about new developments, if there was a new factory in Thailand that had started to manufacture products. They would also pay attention to production, right, of the products that their capacitors would go to, like notebook computers. Like all of us, they would get together and complain when business was bad, right? So they might say, oh, this is a really tough year. And the most common thing that you're going to see when you read these documents is that they're paying close attention to Asian markets. In this particular case, they're talking about an anti-Japan demonstration and whether there might be some impact on the Chinese factories. So these types of discussions, these are not pricing agreements. They're perfectly lawful topics of discussion that different companies in different industries talk about. They can and they do it all the time. So the evidence is not going to show you that every single one of these contacts resulted in a price agreement. And so plaintiffs are not going to be able to support their request for over $400 million in damages here. So second, the evidence is not going to show that 22 defendants conspired. Mr. Finzi explained this chart to you a little bit earlier. There are only 9 companies that admitted to price fixing. And as Mr. Finzi indicated, you're going to see document after document after document with these 9 names because they admitted that they engaged in price fixing conduct. But what you will not see is these names, right? So you will barely ever see these names. These companies were companies that manufactured only film capacitors. Now they had a separate thread of their own meetings where they engaged in permissible information exchange, just like the document that we just covered together. And then finally, you will never see that AVX, Chemet, or United Chemicon actually attended these meetings with these Japanese electrolytic capacitor companies. And this is just another way that plaintiffs have exaggerated the evidence that you'll see and the scope of the conspiracy that we have here. Now third, the evidence is not going to show that over 1,800 purchasers in the United States paid higher prices. Class plaintiffs are going to claim that defendants specifically targeted US markets and customers. They showed you a few isolated examples, and they'll continue to show those to you at trial, of notes where we talk about a US company here or there. But again, I want you to pay close attention to the evidence. I want you to read the whole thing, not just the 1 or 2 lines that class counsel pick out for you. And what you're going to see is that most statements, most topics of conversation were about Japanese customers, not American ones, and were about Asian markets, not the US. And for Matsuo in particular, overcharging 1,700 class members, it's just totally unsupported by the evidence because We used to have a US subsidiary called Matsuo Electronics of America, or MEA. That's what I'm going to call it. And between 2002 to 2009, the only entity that we made direct sales to in the United States was MEA. Right, so why does that matter? That means that if there was a 12-year conspiracy where people were being overcharged year after year after year, between 2002 and 2009, the only entity we were injuring was ourselves, our US subsidiary. And in fact, MEA did so poorly in attempting to sell capacitors in the United States that we actually shut it down in 2009. And because it's now a dissolved company, it is not part of the plaintiff class. So plaintiffs are not seeking any damages for Matsuo's sales to MEA. And even after that closure, we had only 4 customers in the United States, 3 distributor businesses and 1 direct customer. Indeed, over the entire class period, Matsuo's sales to the United States were only 2.5% of its total business. So this idea that Matsuo was targeting the US or targeting these 1,700 or 1,800 businesses in the US, that's just not supported by the evidence. It doesn't make any financial sense for this company. So even though Matsuo engaged in conduct here that it does regret and wants to take responsibility for, it doesn't mean that it injured the 1,700 businesses in the entire class, and it doesn't mean that plaintiffs have supported their claim for over $400 million in damages. So, last, I want to give you a sense of the playing field here. And in fact, class counsel alluded to this earlier today. So let's talk about Matsuo's only US direct purchaser. It's called Continental AG. It manufactures car parts, and Matsuo sells capacitors to it. Continental is one of the plaintiffs here, and it is huge compared to Matsuo. So in 2013, Matsuo had $55 million in business. Continental, that same year, had over $44 billion in business. If you look at this bargaining table, if you look at this negotiation, I think it's pretty clear. Use your common sense. Who's the party dictating prices here? Do you think it's this little supplier, Matsuo? Or do you think it's the Continentals of the world that are dictating the pricing? And in fact, even where price agreements were reached, Mr. Okubo is going to explain to you that where he took those prices to these customers, these name brand, powerful Japanese customers like Canon, like Sony, there were many times where they said no and accepted no price increase at all. And there were other times where they said, we'll take a little portion of what you've asked for, but much smaller than what Matsuo had hoped for. So it's going to be very important to pay close attention to the evidence at trial, because what the plaintiffs have alleged versus what the evidence will show, there's a big delta there about 1, the scope of the conspiracy, 2, the number of defendants involved, and 3, the impact on US customers. My client broke the law. We're here to accept responsibility for what we did. But we're defending where the plaintiffs have been unfair and overreached about the scope of the conspiracy at issue here. Matsuo did not participate in a scheme with 22 defendants over 12 years to fix all capacitor prices for 3 different types of products sold to over 1,800 purchasers in the United States. Matsuo sold to only 4 U.S. customers for a limited period of time, from 2009 to 2013. The narrow and specific price agreements that we will show you and that Matsuo engaged in simply do not support the sweeping conspiracy alleged here and do not support plaintiff's claim for $400 million. Thank you for your attention.
Okay, who's next? All right.
Thank you.
Ms. Clark, can you listen?
Good afternoon,
Get some water.
members of the jury. My name is Joseph Bile. I'm here with my colleague who is at council table, Ms. Farah Burse. Both together we represent United Chemicon. You've heard a little bit about United Chemicon. Also with us today is Mr. Derek Fitzpatrick from United Chemicon. He's a long-standing member of the company. He's going on his 33rd year, actually, in April. And he will be here with us today. I think he's going to also try to join throughout the trial, as you'll see here shortly. United Chemicon is a fairly small company, 220 employees. So he may not be here every day, but when his schedule allows, he will try to be here with us in court. Let me take just a quick moment to tell you about United Chemicon. It's an American company. It's in Chicago. If you've ever been to O'Hare Airport, it's 15 minutes tops once you get out of the airport and drive down the road. So it's very close to Chicago, but it does have other operations in the United States. I will show you both parts of its business. It is the only defendant in this case that manufactures aluminum capacitors here in the United States, the only defendant. You've heard from a lot of defendants, or about a lot of defendants. It's the only aluminum manufacturer in the United States. As you heard earlier, United Chemicon operates under the United States laws. That includes the antitrust laws of the United States. And obviously that's why we're here, about the antitrust laws of the United States. I'll tell you a little bit more about the geographical scope of this company. It's all within the United States. But before I get to that, I want to just underscore one point. You've heard a lot about guilty pleas this morning. You heard it from the plaintiff's counsel and you've heard it from the defense counsel. United Chemicon did not plead guilty. Okay, there's no state in which United Chemicon pled guilty. In fact, the meetings that you've heard about, and I looked at them as they were rolling through the screen, you didn't see United Chemicon at those meetings. In particular, there was a form that was shown. My client was not present at those. And the individuals that will be up here for my client, United Chemicon, some of Mr. Fitzpatrick's colleagues, they'll tell you about those meetings and they'll tell you about the fact that they didn't even know about them, let alone attend those meetings. I'll come back to that at the end of the presentation. Here's a map of the United States. As mentioned, Rolling Meadows is right outside Chicago. That's where the company is headquartered. It's where Mr. Fitzpatrick is from. It's also one of the witnesses who's on the witness list is an individual by the name of Steve Watlock. He's a 25-year alumni. He's still actually at the company, but he's been there for 25 years. He's also a member of the sales force. He will come up and tell you about the company's operations. He's headquartered in Chicago. In addition to that, we'll talk shortly here about the Lansing facility. That's where the aluminum capacitors are manufactured. I brought one with me. I'll talk a little bit about it. That's where these capacitors are manufactured and then priced and sold in the United States. In addition to that Lansing factory and the sales from the manufactured capacitors here in the United States, there's also a facility in Buena Park, California, in Southern California, down the road from us here, where we actually take Asia-based capacitors, they're shipped into the United States, and then they're sold to various customers in the United States. Mr. Watlock will be here to tell you about that operation as well. Here's a picture of the Lansing factory, and as I mentioned, this is the kind of capacitor that we sell from the Lansing factory. Okay, this is not going to fit into your iPhone. Mr. Severi, do you mind if I borrow your client's V-Boost?
As long as you give it back.
I promise I will give it right back.
Just be careful.
I'm going to just hold it just like this. This capacitor is not going to fit into the V-Boost. So the point here being, okay. The point here being, all these capacitors, you've heard some of them, but my client in particular, this is what they sell from the Lansing factory. It has very different uses. How might you use, this is called a screw terminal, a large can screw terminal. How might you use this? It could be used, for example, in a hospital generator. Okay, so power goes out at a hospital, you need electricity, needless to say. That's a very high priority item. These kind of capacitors could power those generators along with batteries and other things. So it's an important use. I think it's probably not going to come as a shock to you that the price of a capacitor like this is going to be much less than the small capacitors that you might find in your iPhone or you might find in an Xbox. And that's important because the differing prices, the differing uses, the plaintiff's case just lumps all this stuff together. It's all just thrown in together and treated in much the same way. And you'll hear more about that. You'll hear that in the evidence. You don't need to listen to the lawyers on that. But that's part of the issue that we wanted to raise with you today, and we'll get into that more in the trial. One other issue about these large can capacitors. The competitors, United Chemicon is the largest seller of these large can capacitors in the United States. Okay, they have the largest market share. Their competitors, though, they're not the defendants that are in the case. If you look at the board that was put up earlier by Mr. Finzi, those companies, they're not the primary competitors for this product. The primary competitors are Cornell Dubilier. That's a United States company. They're not a defendant. They're not alleged to be a co-conspirator. EPCO's company, a German company. Not a defendant, not alleged to be a co-conspirator. Zhanghai, a Chinese company. Not a defendant, not alleged to be a co-conspirator. So why am I telling you this? Well, if my client, United Chemicon, is price fixing these particular capacitors, and those folks, our competitors, are not, we're going to lose sales. If I have a product, if we're all competitors together, and I sell my product at 10, and you all sell it at 6, you're going to take all of my sales. The facts will show that has not happened. We'll have witnesses come up here on the stand to tell you that. We have economists that we've retained. They'll tell you that as well. So it just doesn't hold together. The plaintiff's theory with respect to certainly this Lansing capacitor and those sales, we think the facts will show that's an overreach. Let me turn briefly here to the other side of the company's business, which is the sale of the smaller capacitors. Okay, maybe that's V-Boost. It may even be the smaller capacitors than that, an Xbox or your phone, your smartphones. We also sell those. Okay, we sell the small capacitors. Mr. Watlock, who is, as I mentioned, been with the company for 25 years, he'll tell you how those are sold. He'll tell you how those are priced. I'm not going to try to do that today other than to point out both Mr. Watlock and Mr. Fitzpatrick, they've been at the company longer than this conspiracy. This conspiracy went for 10 or so years. So what that would be saying is, for at least for Mr. Watlock, who will be on the stand, is that every capacitor that he sold during that time period, every aluminum capacitor that he sold during that time period, would have been price fixed, according to the plaintiff's theory. So I'm not going to try to tell you what my view is of the feasibility of that conspiracy. He'll be here to tell you that himself. But it's an important point, and I want to raise it today because we'll be coming back to it when the witnesses take the stand. In addition to that, Mr. Watlock will tell you about some of the NCC, Mr. Finzi's client, Nippon Chemicon. The president of UCC is often an NCC employee who comes over and spends time in the United States. He'll tell you about how that works, and he'll tell you whether that impacts the discretion he has for pricing. And again, I think you will hear that the feasibility of every sale of these capacitors and every sale of these capacitors shipped from Asia into the United States, the notion that they're all price fixed, you will hear from him, and I'm not going to put words in his mouth, but it's just simply not feasible. And the final point I want to make is that these meetings, again, that you've heard about, primarily, you'll see this as they come up and are put in front of you in Japan. Mr. Watlock will testify to this. He's never been to Japan for one of those meetings. He didn't even know about those meetings, and yet we're being told that United Chemicon is part of this grand conspiracy that the plaintiffs have laid out. Again, you'll see that evidence and you'll draw your own conclusion. Let me finish by saying the following. I do believe at the end of the case that the evidence will show that my client, United Chemicon, and its sale of its capacitors were not part of some broad conspiracy that was hatched over in Asia, even though they had never been there to any of those meetings, didn't even know about those meetings. So what I would ask you as a final takeaway, and I actually did this a little bit today myself, when you see documents, and you will see, as sure as I'm standing in front of you right now, you will see documents in this case. When you see those documents, look for the name Derek Fitzpatrick. Look for the name Stephen Watlock. Look for United Chemicon, because those documents that I saw today that were shown on the screens, my client's name was not on those. And that would also go for witnesses. When the witnesses are on the stand, it'll include United Chemicon witnesses, but it'll be other witnesses. The individuals who were alleged to be present at these meetings in Asia, when those witnesses, and I'm going to ask the question, so you're going to hear the answers, when those individuals are asked, well, what about Mr. Watlock? Was he at the meeting? Do you recall him being at the meeting? Were there other United Chemicon representatives at the meeting? Was Mr. Fitzpatrick at the meeting? Just listen to their responses to those questions. That's a very important part of our case, and I would submit, I think this is Mr. Finzey's chart, but United Chemicon here at the top, I believe you will find is part of that overreach. And with that, I want to thank you for your time. I want to thank you for your service on the jury. And finally, I want to thank you for the opportunity we have to tell you our side of the story as well. Thank you.
Okay, who will be next?
Ladies and gentlemen, AVX was not there. AVX was not there in person. AVX was not there in spirit. My name is Bruce Sokler. I'm counsel for AVX. Part of the AVX trial team includes Rob Kidwell, Ralph Capello, Brett Quinn, Alexandria Cavelli, and Sean Skolke. Also here is AVX's corporate representative, Evan Slavitt, who was Senior Vice President of AVX. As you've figured out already, you're going to see a lot of lawyers at this trial. And I just introduced you to a bunch of lawyers who are going to be on the AVX trial team. We're going to try to give you a hint so you know when one of us is speaking. We're going to wear orange ties and orange scarves. And that's because AVX is located in Greenville, South Carolina. And so we chose the colors of the nearest college to Greenville, Clemson University. They're orange, and sometimes we'll even have a tiger paw. So when you see the orange, you'll know that it's an AVX person talking. AVX is a New York Stock Exchange company located in Greenville, South Carolina. President of AVX, Mr. Johnny Sarvis, will be testifying at trial. Mr. Sarvis has been in AVX for 35 years. Mr. Sarvis and AVX have been waiting for nearly 6 years to come to tell a jury like you, ladies and gentlemen, that AVX did not price fix and AVX was not part of the conspiracy. That is what Mr. Sarvis will testify. Mr. Sarvis will also tell you about the background of AVX. The company goes back to the 1930s, and he'll tell you about the business of AVX. AVX makes a whole range of electronic components. They make connectors, they make inductors, they make ceramic capacitors, which are not part of the case. They do not make aluminum capacitors, which are also part of the case. The reason AVX apparently is in the case is because of the tantalum capacitors, which is part of AVX's business. But you'll find, as Mr. Sarvis will testify, and the facts will show, that AVX focuses on unique, high-quality capacitors for U.S. industries. The capacitors it makes are used in defense company uses, it's used in outer space, it's used in large train. In fact, AVX worked with NASA and the European Space Society and the design of the Mars rover. And there are over 300 AVX capacitors currently sitting on Mars in the rover. High quality, specialized capacitors are not only big capacitors, sometimes they have to be very small. AVX makes some of the smallest tantalum capacitors in the world. These are capacitors that go into implants into the heart. These are capacitors that go into your ear for hearing aids and uses such as that. AVX also makes some large, high-powered film capacitors used for power plants, trains, and electric vehicles. These can sometimes be a couple of feet high. They can weigh 50, 100 pounds. They're not sort of the commodity film capacitors that are being talked about as being part of the conspiracy. Now, Mr. Sarvis will also testify that AVX makes the commodity capacitors. It's tantalum capacitors. It's a small part of their business, but they do it for the convenience of their customers, so they have an entire line of products to sell. In fact, Mr. Sarvis will testify that within AVX they have a name for those commodity capacitors. They call them popcorn. Be thrown in with the rest of the things they're supposed to sell. In fact, much of their sales are in combination with those other products we were talking about, because the customer is looking for the range of products and have a single negotiation in which various prices are negotiated for the products. But it's the entire package that's important to AVX. And what margin or profit comes out of the higher package is important. You've heard about tantalum a couple of times today. And I thought I should spend a minute or two on tantalum, because tantalum also was a very important issue during the period that plaintiffs claim that some conspiracy was going on. As you may know, tantalum is a natural mineral. It's number 72 on the periodic table. It's mined around the world, and in fact, in the 2000s, the mining of tantalum became a very controversial matter, because some of the places it was mined were places that were run by warlords, were controversial, sometimes used child labor. As a consequence, tantalum became one of the 4 so-called conflict minerals. And there was a lot of dispute about whether products should continue to have conflict minerals. And there was a lot of resistance to customers buying products unless they knew that the supply chain was clean of conflict minerals. AVX took this issue head on. And you'll hear testimony at the trial from Mr. William Millman, who was the AVX official who was put in charge of that issue. And AVX helped create an organization called for Solutions for Hope, which was created to get conflict minerals out of the supply chain. And they worked with the United States government, the United Nations, and organizations in Africa to do this. Mr. Millman talked with everybody. He talked with people who mined it, people who smelted it, people who used it, and also with his competitors, because they all have the common interest to get a conflict-free supply chain for tantalum. And in fact, finally, the US government passed a law that required that, which AVX required to. It was part of the so-called Dodd-Frank law, if you've heard of that. So not all meetings are suspicious. Not all contacts with competitors are suspicious. Mr. Millman's contacts, for example, on the conflict mineral issue certainly aren't suspicious. Meetings where you run into your competitors when your customers invite all their suppliers to a supply day aren't suspicious. Meetings of trade associations aren't inherently suspicious, but they were all on plaintiff's rolling list of 1,800 contacts. And you'll see when the evidence comes in and at the end of the case, there's not much there. We ask you to focus on what evidence in this case applies to AVX and what doesn't apply to AVX. You've heard all day about meetings, minutes, different groups. AVX wasn't in those meetings. AVX isn't in those minutes as attending those meetings. AVX didn't receive minutes from those meetings. You've heard about criminal proceedings and you've heard about criminal pleas. You'll hear nothing about AVX on those subjects. AVX did not plead guilty to anything. This case, I think you'll see from the evidence, is focused on Japan, focused on meetings that occurred in Japan, focused on meetings that were in Japanese, focused on the Japan market primarily and other Asian markets during a period of time where AVX had very little business in Japan. You'll also see evidence in the case where those people who were at the meetings recognize that not only that the American companies like AVX and Kemet not part of the conspiracy, but their activities were unhelpful and were making life harder for the members of the conspiracy. AVX was not part of any price fixing. Kemet was not part of any price fixing. Plaintiff's counsel talked about, well, sometimes somebody talked about AVX, gave some AVX information during some of those meetings. And some of those minutes, you'll see, do reflect that. We would suggest you remember, and the evidence will show, and Mr. Sarvis will testify, that AVX is a public company, a New York Stock Exchange company. And under the law, public companies have to make public reports and file them. And if you're a New York Stock Exchange company, you have to have public press conference, quarterly reports, all of this available to anybody in the world, at which you talk about how's your business doing and how your business is about to do, at which you talk about pricing trends, at which you talk about your lead times to delivery, how you expect the next quarter is likely to go. Is business going up, going down? You make estimates of your profit and your margin. What plaintiffs will not be able to show that any of this information was part of any price fix between AVX and anybody else in Japan. So one question you'll have to answer, and one question you're probably already asking yourself, is why is AVX in the case? And you've heard, especially when AVX was in South Carolina, and all these meetings that you've heard about all day were in Japan and in Asia. Well, I think you'll figure out the answer, or I would suggest the evidence will lead you to the answer when you look at the damages that plaintiffs are claiming. Plaintiffs' counsel told you that they will ask you for $427 million in damages. In the information they provided us before the trial started, they showed us how they built up $427 million in damages. At the top of the list, at $85 million total, is AVX. Next on the list, the other American company, Kemet, 77. And so if you look at that, just those two things, you'll see that they basically have increased their damages by 50% by throwing in the American companies. If you look at 10 of them, it gets even worse. 90% of their alleged tantalum damages come from the two American companies. Plaintiff's counsel talked to you about how he's going to put on an expert, Dr. Singer, who's going to talk about suspicious contacts between defendants, and he's included apparently suspicious contacts that he attributes to AVX. Well, we have an expert who will testify in this trial, Dr. Timothy Snail, who's a PhD economist whose degree is from Berkeley. Dr. Snail did two common sense logical things. You also heard that we have a database of all the transactions of all the parties during all the period of time that this conspiracy was alleged. Where Dr. Snail looked at those transactions and looked at these so-called suspicious contacts and analyzed whether he could see any pricing effect that correlates to any of those contacts. He found none. Moreover, he also did a second test. If we were in a price-fixing conspiracy with the Japanese companies, particularly the ones who pled guilty, wouldn't the data show a correlation between our prices and theirs? So he did that analysis. He found none. Why? Because AVX did not price fix, and the evidence will show AVX was not part of this conspiracy. Ladies and gentlemen, when you use your common sense and your judgment at the end of this case and look at the evidence, we think it will be easy for you to enter judgment for AVX. Thank you for your attention.
Okay, and who will be the last speaker? All right, let's be mindful of the time, please.
I wanted to raise that. Given Your Honor's desire to finish at 2, and we're running about...
We are going to finish today. You'll just have to make it succinct.
Okay.
Go ahead.
Thank you, Your Honor.
We're going to finish openings today. We're not going to finish.
Thank you, sir.
Yeah. You can hear me, right?
Yeah.
Okay. Class counsel began his remarks this morning by telling you something very specific. He said the defendants, and this is a quote, agreed with each other that they would raise prices when they could. When they could. That is going to be a critical piece of this case because class counsel acknowledged right at the start of this case the critical point that agreeing to raise prices doesn't mean that the participants actually succeed in doing that. And a key question that you're going to have to answer in this case is whether they could actually increase prices in the dramatic way that the plaintiffs have alleged here. And that's a decision you'll have to make. Could the defendants actually raise prices across 7 million purchases by nearly 1,800 class members for thousands of different products from 22 defendants year after year for 12 years worldwide? Because that's what they're asking you to conclude. And as the judge instructed you this morning, it is the class plaintiff's burden to prove exactly that. Good morning. I'm David Cross, and I represent Matsuo. I'm going to speak to you on behalf of all of the defendants about a subject that concerns all of our respective clients, and that's the economic analysis that the class plaintiffs will present to try to meet their burden to prove two essential elements: injury and damages. Well, the evidence will show that Dr. McClave's analysis that you heard about earlier is designed to generate massive damages. And you're going to see that the class case depends on the accuracy of his analysis. It is the linchpin of the injury and the over $400 million in damages that they're going to ask for. And let's be clear about what their conspiracy is. This is how the court summarized it for you earlier. And I want to just draw your attention to the last sentence here of what the judge read to you. He summarized the conspiracy, and then he said, the DPPs, the class plaintiffs, have the burden of proving this alleged conspiracy. Not some other conspiracy, this conspiracy. It is that conspiracy, the overarching, all-encompassing conspiracy that underpins their claim for damages of $427 million. Now, what's their burden? They've got to prove injury for a class that includes 1,800 businesses, and they've got to prove damages in a way that's precise enough to be non-speculative and not guesswork. And what we're going to show you is that Dr. McClave's economic analysis, what he calls his econometric model. You're going to hear a lot about econometric models. That's his analysis underlying the damages and injury. We're going to show you that it's wrong, and it is, at best, guesswork. Now, first, let me introduce you to another economic expert that's going to testify, Dr. Layla Hayter. She's a PhD economist who received her doctorate degree from Columbia University. She has 20 years of experience as an economist, and focusing specifically on antitrust economics, which of course will be the focus in this case. We are going to call Dr. Hayter to testify, and she'll respond to the econometric work that the plaintiff's experts, Dr. McClave and Dr. Singer, they also talked about.